Question before the House is, will the House adopt the amendment offered by the gentleman? On that question from Lehigh County, Chair recognizes Representative Ritter.
Thank you, Mr. Speaker. I rise to state my opposition to Representative Friend's amendment and to urge this House to reject this proposal, which trivializes some of the most important and difficult decisions that a woman can make. I find it ironic that I'm in my third year in the House of Representatives and I'm here debating my third Abortion Control Act. May I remind my colleagues that we did this in 1987 and in 1988, and here we are again in 1989. May I also suggest to my colleagues that it is likely that we will be here in 1990, 1991, and 1992 debating this issue, or until a majority of the members of this body say enough is enough. Pennsylvania has some of the strongest abortion laws in the country on the books and has provided a litany of United States Supreme Court cases that have overturned unconstitutional anti-abortion statutes. Why are we doing this today? Because we want to send still another case to the U.S. Supreme Court. What we are doing is deciding whether or not to provide the U.S. Supreme Court with the case that will overturn Roe v. Wade, which made abortion legal almost 17 years ago. If that happens, ladies and gentlemen, we won't be here debating specious abortion regulations which are designed to harass women and doctors. We will be here deciding whether or not abortion should be legal in Pennsylvania. If you think you are uncomfortable now, and if you sense more being at stake as you cast your votes today in terms of your political future, just think about how painful it's going to be, both personally and professionally, to decide in the not-too-distant future if abortion should be legal or illegal in Pennsylvania. That is the issue. For the record, let me make it very clear to you that nobody likes abortion. I am not advocating and have never advocated abortion on demand after viability. I want to reduce the need for abortion by reducing unintended pregnancies. I believe that this country wouldn't have the highest abortion and teen pregnancy rate in the developing world if we took sex education and family planning more seriously. But unfortunately, we don't. I believe that the best way to prevent abortions is to help women not get pregnant in the first place. Many women who experience unintended pregnancies have used contraceptives that failed. 50,786 women in Pennsylvania made the decision to have an abortion in 1988. According to the Population Crisis Committee, Mexico, our neighbor to the south, has approximately the same number of abortions annually as this country does, about 1.5 million. But all abortions in Mexico are illegal. An estimated 140,000 Mexican women died last year as a direct result of consequences of illegal abortions. Almost 1 in 10 Mexican women who have abortion dies. By contrast, in 1988, 6 women died in this country where abortion is legal. Again, by voting for this legislation, you will be taking another step towards a vote on whether or not abortion should be legal in Pennsylvania. Now, Representative Friend would have you believe that a woman can have an abortion during all 9 months of pregnancy and that that is what pro-choice people support. This could not be further from the truth. Of the over 50,000 abortions performed in Pennsylvania in 1988, 93.5% were performed in the first trimester of pregnancy, according to figures from the Pennsylvania Department of Health. There were 127 abortions from the 23rd to the 26th week of gestational age, which begins 2 weeks before conception in this legislation. In all of Pennsylvania last year, there was just 1 abortion in the 3rd trimester. Any procedure performed after the 24th week is considered a premature delivery, and every effort is made to save that child if it's possible for the child to survive. These premature deliveries are performed because of serious health complications to the woman or her child. Saline abortions and D&Es are not performed after viability in this state or in any other state. So the abortion that Representative Friend refers to that can be performed up to 30 seconds before birth simply means that the baby will be delivered 30 seconds earlier. That's all. By now, we have all heard Representative Friend's recitation of the terrible story of Dr. Melnick and West Park Hospital so many times that we can probably repeat it word for word. Let me say at the outset, in this instance, I do agree with Representative Friend. What the doctor did was wrong. illegal, and punishable under the laws of this Commonwealth. The doctor was charged, tried, and convicted under the infanticide provision of current law. That story is an aberration, but one that suits Representative Friend's purposes in attempting to convince you that women are having late abortions as a matter of whim. Believe me, they are not. So what's wrong with this bill? Let's start with the definitions. We have defined gestational age to mean a probable 2 weeks before a woman conceives. So the prohibition on abortions after 24 weeks gestational age is 22 weeks or less post-conception, which bumps right into a few cases where amniocentesis results may show severe fetal anomalies. We have also now defined unborn child and fetus as meaning the same thing from fertilization until live birth. Now, the doctors that I have talked to call a fertilized ovum an embryo until 8 weeks post-conception, and then they call it a fetus until it is born. Representative Friend wants us to think of all fertilized eggs, even at the moment the sperm enters the egg, as an unborn child. Now, I don't doubt that the potential for a child exists, nor do I contest the notion that there is life there, but I firmly believe that the woman's rights are more important until that time in the pregnancy when the fetus can survive outside the woman's body. I also believe that religious differences of opinion must be respected, as different religions approach the issue of when life begins from different perspectives. From the beginning of time, women have borne and raised children. Why can't we trust women to make their own decisions about whether or when to have a child? Must we continually subject women and their doctors to unnecessary, expensive, and time-consuming delay in order to satisfy the wishes of my anti-choice colleagues? Make no mistake about it, this bill will not prevent abortions. It is not designed to prevent abortions. All it will do is add time, money, and hassle to women in Pennsylvania seeking abortions and the few doctors who still provide them, and provide the all-important challenge to Roe versus Wade. Women are not stupid, as this bill would have you believe. When a woman makes up her mind to have an abortion, she knows what she is doing. That doesn't mean she takes it lightly. That doesn't mean that there are no emotional consequences for her actions, and that doesn't mean that it's an easy decision for her to make. But the important point here is that it is her decision to make, based on her judgment and the circumstances of her life. It is not for us in government to make that decision, to interfere and intrude in one of the most personal and private decisions that a woman can make. A woman will involve her husband in the decision-making process if theirs is a healthy relationship. Who are we to intrude in something so private and force someone to write down in their medical records that their husband is not the father of their child, that they fear physical abuse, or that, most intrusive of all, if the pregnancy results from spousal rape, the woman must report it to the police? This is not the role of government in the marital relationship. The 1989 version of the Abortion Control Act, which 73 of my colleagues saw fit to sponsor, most without seeing the actual language, also requires that a woman wait for 24 hours after receiving informed consent before she can have the abortion. Ostensibly, this waiting period is to give her time to think about what she's doing so that perhaps she can change her mind. Now, the odds are that this woman has been pregnant for 6 weeks to 2 months and possibly longer. She's decided what she wants to do. She's called the clinic for an appointment, which I'm sure she's not looking forward to. And now we want her to wait for another 24 hours or more in most cases, since clinics don't perform these procedures every day in many areas of the state. We want her to wait for another 24 hours after receiving informed consent. For what purpose? Or should I say, for whose purpose? Last year, women from each and every county in this state had abortions. Most of them couldn't have them in their own communities because there are no abortion providers there. So they have to travel, just like pregnant women in rural areas frequently have to travel for prenatal care. There are abortion clinics in Allegheny, Chester, Dauphin, Delaware, Lehigh, Montgomery, Philadelphia, and York counties. That's 8. A few abortions were performed in 17 other counties. The residents of the remaining 42 counties have to travel, many for considerable distances. For some, it's easier to go out of state. Now we will have them either make 2 trips or stay overnight. More time, more expense, more travel. Pennsylvania has the largest rural population in the country. And for those of you who represent rural areas, you know how difficult it is for women, for people to get health care. Now we have these women who must leave their communities to get this procedure, coming to a strange city for an abortion. Their husband, boyfriend, parent, friend, or sibling may or may not be with them. They may have to run the gauntlet of anti-abortion protesters to get into the clinic, and now there will be another 24-hour wait before they can get the procedure. Will the anti-abortion protesters be taking down license plate numbers, as they have been known to do, so that they can call these women's families? Will they follow these women back home or to a motel to try to convince them not to have an abortion? This provision, this 24-hour waiting period, was struck down by the U.S. Supreme Court in 1983 as unconstitutional harassment. It will add time and expense to the abortion procedure. No big deal, you say, so she has to wait 24 hours. Tell that to the women who live in the real world. And what shall we do about sex selection abortions? This is a terrible practice in other countries like India and China, but we don't do it here. Now, Representative Friend, in one of his amazing memos, compares this to the NBA rule, no harm, no foul. This is not a basketball game. This is not trivial. Women in our country do not have abortions for this reason. But think about it. The reason this provision is included in this bill is not to stop this horrible practice. It is included because this section directly challenges Roe versus Wade. That's what's going on here. Will someone please tell me just how it is that a doctor who risks a felony conviction for performing an abortion for this reason will know that this is someone's reason for having an abortion? Can you imagine the cross-examination that would have to take place to prove that someone actually did this? This provision will not pose a particular problem for the vast majority of abortions performed in Pennsylvania because they are done, as I said, before it is possible to detect the sex of the fetus. But what of sex-linked genetic disorders like hemophilia or Duchenne's muscular dystrophy? Although we say in this section solely because of the sex of the unborn child, how is someone to prove that it is solely for this reason? Who makes that determination? Many of my colleagues will be sharing the responsibility today to debate portions of this legislation, and I will not attempt to do it all now. But there is one piece of this legislation that strikes me as particularly onerous and very mean-spirited. In the prohibition against abortion after 24 weeks, there is a particular exclusion for suicide. It actually read in the original version of the Abortion Control Act, which we saw for the first time less than 3 weeks ago, no abortion shall be deemed necessary to prevent the death of a pregnant woman if such death would result from suicide. I can only hope that most of my colleagues didn't know this language was in there before they sponsored this legislation. Now it reads, no abortion shall be deemed authorized under this paragraph if performed on the basis of a claim or a diagnosis that the woman will engage in conduct which would result in her death or in substantial or irreversible impairment of major bodily function. Now, this change only addresses women who have, in fact, attempted suicide, but makes no exceptions for women who have been diagnosed with mental illnesses that make them suicidal. I encourage you once again to read the case studies from Choice in Philadelphia that you received from Representative Hughes about the women who attempted to self-abort or kill themselves rather than carry to term. Are we to say to the doctors, psychiatrists, and social workers who deal with these tragic situations, yes, tell this woman to go ahead and kill herself and her baby, we can't help her? Do we say that to the woman who was so desperate in Philadelphia that she stabbed herself in the stomach? Or to the woman in my hometown who took 5 packs of birth control pills? Or the women who tried to overdose on cocaine and alcohol because they couldn't figure out what else to do? As I said, what about women who already have diagnosed mental illnesses? Let's please remember that in situations like this, people are desperate. We owe them compassion and understanding, not cruelty and heartlessness. Think of what it must be like for a psychiatric social worker to tell a woman that she's sorry, but the legislature said that if she was going...
Mr. Speaker. Gentleman from Center County, Mr. Letterman. For what purpose does the gentleman rise?
Mr. Speaker, I have my doubts if the Speaker is staying on the amendments. I've been listening, and I would think that the day is going to be long enough if we don't stick to the amendments. If you're going to do it point by point, and let's hear it. But let's not just ramble on about every doctor in the United States. We don't need to hear that.
The day will be indeed long if we interrupt speakers. The lady is speaking on the amendment. The Speaker determines that she is on the amendment.
Speaker. Watch yourself, Jim.
What purpose, the gentleman rise?
I will continue to insist that we stay on the amendments.
All members must stay on the subject before the House. The subject before the House is the amendment. The lady is in order and may continue.
Thank you, Mr. Speaker. Think of what it must be like for a psychiatric social worker to tell a woman that she's sorry, but the legislature said that if she was going to kill herself because she couldn't have an abortion, that she should just go ahead and do it. How many women will be permanently impaired or will just die in their attempts to do something to seek help? Talk to some of the people who deal with these situations all the time and ask them how hard it is to get the system to believe that someone is really going to do this. I entreat you to get rid of this provision. Mr. Speaker, I want to conclude my remarks by saying that this issue is one that has the potential to tear our legislature, our state, and our country apart. It appears to have the potential to change the political landscape in the state. It has already assumed some aspects of a civil war, and I expect it will get worse before it gets better, unfortunately. It's my sincere hope that our activities today will reflect thoughtful deliberation. This issue is too important and affects too many lives not to pay attention, read, question, and consider. In the aftermath of the Webster decision last July, the Supreme Court changed everything and nothing at the same time. The major body of law dealing with this subject has not changed, and the Supreme Court itself is being pulled apart over this issue. This amendment before us today does not incorporate any provision of the Webster decision. I intend to offer an amendment today to use the U.S. Supreme Court's language from the Webster case about viability testing, which the sponsors of this legislation have not done. I ask my colleagues to resist the pressure to be the ones to give the court the test case to overturn Roe. And I ask you to realize that we may reap a bitter harvest from our actions today. For too long, many of my colleagues have been comfortable in voting against a woman's right to choose because they always thought the court would be there to back them up. That may not be the case anymore, and we will all have to live with the repercussions of what we do here today. I urge my colleagues to look down the road ahead and imagine a state without safe and legal abortion. Imagine the pain and suffering that would cause thousands of women and their families in the years ahead. And finally, Mr. Speaker, I urge my colleagues to remember one thing. Trust the women to make these important decisions for themselves. I urge a no vote on the Friend Amendment. Thank you, Mr. Speaker.
Question is, will the House agree to the amendment? On that question, Chair recognizes from Philadelphia, Representative Harper.
Thank you, Mr. Speaker. I rise to ask the members to reject Representative Friend's amendment. I refer especially to Section 3209, the spousal notice. I would just like to say that I can't imagine a woman being in the position to go to her spouse to ask for permission for what can she do with her body. I know from self-experience, I'm the mother of 2 children, and I told my husband that we can only afford 2 children. I will not have any more children. And I wouldn't think of going to him to ask him, what can I do with my body? And I would not try to enforce that on any other woman. This legislation will only harm poor women, women that cannot afford to have an abortion. They will revert to back room, the coat hangers, and self-abortions. And I would just like to say that I would like to see a number of legislators work hard on family planning. We would not have all of these abortions if we would work on education, educated women, and family planning. That's where the problem is, in the lack of family planning. And I just read this article in the Patriot News today on health care. Half of the poor children are not receiving health care. Why can't we fight for health care for senior citizens and poor children? We're not concerned about women. We're not concerned about poor children. We're only concerned about telling women what they can do with their bodies. Well, I'm here to tell you, this is one that you will not tell. No one has been able to tell me, and I will fight for other women to have that choice. I will fight to the bitter end for the right to choose. Thank you.
On the question of the amendment, from Bucks County, the chair recognizes Representative Heckler.
Thank you. I would ask that the maker of the amendment stand for a brief interrogation.
Gentleman indicates that he will stand for interrogation, and you may proceed.
Thank you, Mr. Speaker. Mr. Speaker, could you inform the House how your amendment responds to the decision of the Supreme Court in Webster?
I'd be happy to, and I thought, and I'm not being smart here, that that was the first thing we covered in the first memo that went out, the analysis. The United States Supreme Court in the Webster case gave what is termed as a, quote, rational basis, unquote, decision, as opposed to strict scrutiny. What it in fact seems to be saying is that it is permissible to regulate, restrict, and in certain cases outlaw abortions if there is in fact a rational basis for doing so. Accordingly, there are regulations in here, not just to restrict abortions, but to protect the victims. There's a prohibition against sex selection because remember what Roe said was that only abortions which are necessary, and that is also existing Pennsylvania law. So we are saying that sex selection is not necessary. So in point of fact, because of the rational basis decision, and if you read the opinions of the court, that's what they're giving, we have taken the opportunity to move forward in what we consider a very moderate, common sense manner.
But, Mr. Speaker, it would then be fair to say that the specific areas of restriction and regulation which are proposed in this amendment were not addressed in the Missouri law which was reviewed by the Supreme Court in Webster?
That's absolutely correct, Mr. Speaker. We've always indicated that. In point of fact, Missouri's existing law, including those which were upheld in the Webster case, are not as protective of all of the victims of abortions, the unborn baby, the mother, and others, as existing Pennsylvania law.
Mr. Speaker, could you please explain the purpose of the redefinitions which are contained in the beginning of your amendment of the terms fertilization and conception, pregnant, and fetus?
Okay, with respect to conception, we just made it clear that conception and fertilization shall mean the same thing. We took a very verbose existing definition of fertilization and merely simplified it to say each term, meaning fertilization and conception, shall mean the fusion of a human's spermatozoon with a human ovum. That is when the sperm is united with the egg. What were the other questions, Mr. Speaker? Yeah, I've been indicating one of the reasons why that this section conforms to Doolan's Medical Dictionary, and therefore was merely to clarify. No hidden agenda here, Mr. Speaker.
Well, specifically, is it your opinion, if you have an opinion, Mr. Speaker, that the definitions, that the redefinitions which you propose would include an in vitro situation, the bringing together of a sperm and an egg in an in vitro situation within your definitions?
No more than in the present situation, we specifically, existing law, exempt in vitro fertilization from any type of regulation except the reporting requirement. This legislation doesn't change it.
Could you advise us with regard to the issue of contraception and the issue of the IUD, what impact, if any, these redefinitions have?
Absolutely none whatsoever. Let me repeat for the record. Contraception is the prevention of life. Private issue, no government interference. Abortion is the killing of an unborn child, and at least in my opinion, as a matter of public policy, should be regulated and, quite frankly, restricted as much as possible. Let me further say that the existing definition of abortion, which we don't change, makes this very clear. Quote, this is abortion, the use of any means to terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will, with reasonable likelihood, cause the death of the unborn child, except that, for the purposes of this chapter, and we're talking about the Abortion Control Act, abortion shall not mean the use of an intrauterine device or birth control pill to inhibit or prevent ovulation, fertilization, or the implantation of a fertilized ovum within the uterus.
So that it is your intention that those exceptions will continue to apply?
Not just my intention, Mr. Speaker. We haven't changed the definition. Absolutely. Once again, no hidden agendas.
Mr. Speaker, are you aware, apart from the Melnick case, of any other late-term abortion which has been performed in the Commonwealth of Pennsylvania since the passage of the original Abortion Control Act, which has resulted in the birth of a live fetus or a fetus which has been permitted to die or prevented from gaining life, as occurred in the Melnick case?
Well, number one, and not to be smart, there is no such thing as a birth of a live fetus, because by anybody's definition, when that baby is outside the mother, that's a baby. Number two, if it happens once, it happened too much. Number three, the interesting part here is, had the same doctor killed the same 3-pound, 8-ounce baby girl, had he been a little craftier and killed the same baby girl while she was still inside her mother, that would have been a legally permissible abortion. So in point of fact, this can occur any number of times and is legally permissible. And as I also repeat, the Philadelphia Inquirer, in their article, Abortion, the Dreaded Complication, indicated several years ago that it occurs at least once a day in the United States. But I've always said, Mr. Speaker, that if everything we do results in one travesty not occurring, one abortion not being performed, particularly in an outrageous case like this, one baby being born instead of killed, then everything we've done with respect to this has been a success.
Mr. Speaker, is it correct that your legislation will not require, as I believe you indicated, but I'd like to be clear about this, would not require any but the normal procedure which a physician would undergo to determine gestational age when confronted with a pregnant woman who is his patient?
Absolutely, Mr. Speaker. And once again, I think you know me well enough. What you see is what you get. Absolutely, the language is very clear there. If we wanted to require an ultrasound in every case, then we would say it. Reasonable standards existing in the medical profession.
Mr. Speaker, have you researched in any measure the kinds of medical crises which may confront a woman in a late-term pregnancy situation and her doctor, which may give rise to threats to the woman's well-being and the question at least being raised of the need for an abortion?
Well, of course, well-being is an extremely broad term. This bill states the position that in cases, even in a late term after 24 weeks, where an abortion is necessary to avert the death of the mother or to avert substantial and irreversible impairment of major bodily function, the abortion will be permissible. And once again, let me say, Mr. Speaker, we don't take this lightly. We don't take any health threat lightly. We even accommodated with our language, with our change. But remember here that this requires, by definition, a very careful balancing act. When it's life, it comes down in favor of the mother. When it's life, irreversible, and substantial cessation of major bodily function, it comes down in the favor of the mother. When it's less than that, when it's health against the life of the baby, then it comes down in favor of the unborn baby. When one is weighing life against health, the scales have to be tipped in favor of life. And that's not said in a cavalier or callous manner.
Mr. Speaker, would it be correct that if your amendment were enacted and became law, and a woman was confronted with a situation in which she was advised in, let's say, her 8th month of pregnancy by a physician that she was carrying an anencephalic fetus, a fetus with no brain, which the physician informed her would surely be born either dead or to die within a matter of hours? Is it correct that your language would prohibit her from seeking an abortion prior to whatever natural processes would produce a delivery?
That's correct, and I believe, Mr. Speaker, we'll get into extensive debate on that on the amendment. But there are some fundamental issues that have to be addressed. One of which is, if the baby might not be, quote, normal, unquote, it's okay to kill the unborn baby. And the problem you come into, and you can give every hard case in the world, is what's normal and who is keeping score? Anencephalic? How about Down syndrome? How about cleft palate? How about freckles or a lisp or red hair? Other societies at other times have tried to, quote, clean up society, and we've seen the results. This is the old, quote, quality of life ethic that argues that life is reserved for the planned, the privileged, and the perfect.
If
And when
I
we
may,
embrace
Mr.
that, we begin to cease to exist as a civilized society.
Thank you. Mr. Speaker, I wonder if I might speak on the amendment.
Gentleman is in order.
Mr. Speaker, today I hope that for the first time the Pennsylvania legislature is going to take up a revision to the Abortion Control Act in a real-world context. In the past, amendments have rolled through this legislature with very little question, apart from whether or not they were sufficiently anti-abortion. One of the saving graces to this approach to legislation has been the fact that as soon as this legislation left the governor's desk, it was enjoined by a federal court never to actually have impact upon those who sent us here to legislate in their behalf. However, we recognize that today we are in a post-Webster world, and I would suggest to you that the issue is not so much whether you or I are going to have to pay some political consequence for whatever vote we cast, but rather that our constituents are liable to actually have to live under the laws we pass. Now, we're used to that in other matters. And in other matters, we give careful, deliberative concern to what we do. In this matter, we have had, a bit more than a month's consideration since this bill was passed. We succeeded in having one hearing in the House Judiciary Committee, about which the prime sponsor suggested that it wasn't going to change anybody's votes. I wish each of you could have been there to hear the testimony that was presented, presumably, at least from one side, in hopes of justifying this legislation. We heard from 3 witnesses on the pro-life side. One talked about conditions in Texas in the late 1970s and early 1980s. One talked about the issue of consent to abortions. Her experience was Massachusetts in the early to mid-1970s. And the other witness talked about the Melnick case, which we can all agree was a violation of present law, a judge having so found, and was a situation which should be against the law. I urge that each of you think carefully about this amendment and about each of the amendments which follows. Recognize that what you're doing for the first time may actually have to be dealt with by your constituents. And consider the answers, or I would suggest non-answers, the rhetoric that you've just heard in response to my questions. Has there been any research or consideration to the kinds of real-world medical conditions which will confront a pregnant woman, a woman who may want very badly to bear a child, but whose life, whose medical well-being is threatened? Did you hear an adequate answer to that question? I urge that you pay close attention to the debate as it goes forward, and I urge that we be spared that debate by the defeat of the Friend Amendment. Thank you.
Question is on the amendment. On that question from Wayne County, Representative Bermelin.
Thank you, Mr. Speaker. I will be brief, and I will try to get right to the heart of the matter. There are, of course, the standard arguments that we've heard all along in this debate. Obviously, they will not change a whole lot of people's minds, and so I won't belabor the point. I just want to bring focus back to the issue that we're concerned with. First of all, I think, as the Representative Friend has said, this bill is a reasonable attempt to control an area of human endeavor and life that is absolutely critical and necessary in society. To suggest that women should be able to end the life of an unborn child without knowing about all the facts, without having at least her husband in some cases aware of it, and to be informed and to make a choice on that is ludicrous. We wouldn't suggest that heart transplants do that. We wouldn't suggest that people who have major surgery just pop into the doctor's office and get it done right away without even thinking about it. So I believe it's reasonable legislation. It's in the best interest of the mother and the child. And I think also we have to put the issue to the bottom line. We cannot place considerations of convenience, hardships, special cases above that of the right to life. And that's what this bill is all about. It's about the right to life. Do we enforce it, and do we guarantee it to all of our citizens, or do we say, no, we're only going to give it to those who pop out of the womb 9 months after conception simply because they could not live on their own beforehand? Well, I think that's wrong. I think this legislation is needed. In some ways, I wished it went further, but we'll take it one step at a time, as Representative Friend says, and I would ask for your support of this amendment. Thank you.
On the amendment, question is on the amendment. On that question from Philadelphia, Representative Weston.
Thank you, Mr. Speaker. As a legislator, I have always viewed protection of our citizens as the most important part of our job. I believe that supporting Representative Friend's amendment gives us the opportunity to do just that. As a woman and as a mother, I fully endorse better regulating an industry which affects so many of our female citizens. Making sure that women are better informed about such a crucial decision in their lives is our serious responsibility. To give unborn children better protection, the best protection we can under the law, is just as much a serious responsibility. I believe Representative Friend's amendment brings us closer to providing the kind of protection our citizens, born and unborn, need in Pennsylvania. I fully support this amendment. I will oppose any weakening amendments, and I urge all members to do the same. Thank you.
On the amendment from Philadelphia, Representative Josephs.
Thank you, Mr. Speaker. I rise to ask my fellow House members to oppose this amendment. And I want to remind you that the rational approach which this amendment pretends to take is very misleading. I have worked on this issue. I have worked for a woman's right to choose, for a family's right to have privacy, for about 17 years, since before the decision of Roe v. Wade in 1973. I know that the ultimate aim of the self-styled pro-life movement is to outlaw contraception. I hope that we can discuss that later on in an amendment. But to reiterate what several of my colleagues have said, we are operating now in an atmosphere where not only do our constituents have to live or may have to live with what we pass, but when the public, having felt that it has lost the protection of the court system, will turn to us to protect their rights to privacy, their right to familial autonomy, their right to make deeply personal decisions without the interference of this legislature. The question we are facing here is who decides? Who makes this personal family decision? And I would remind you that we are embarking here on a very, very slippery slope. And I can illustrate that in many ways, but let me take the proposition that we can, or we should, or it makes any sense to try and outlaw sex selection as a reason for terminating a pregnancy. I believe that no woman, no family of any woman needs to give a reason for terminating a pregnancy to her physician. If we have a First Amendment in this country that allows us to speak, I believe we have a reciprocal right which allows us, under certain circumstances, and this is certainly one, to remain silent. Right now, my colleagues in the House, it looks as if voting against sex selection amendment, a sex selection abortion, is a throwaway. But tomorrow, we may be deciding between other reasons that a woman may or may not have an early pregnancy termination. We may be back here in 6 months, in a year, trying to decide whether a woman should have an early abortion, should be allowed to have one, because she fears to suffer terrible pain in labor and delivery. Is that a good reason? Is that a bad reason? Do we want to make that decision? I don't. We may be here deciding whether a patient can have an abortion because the pregnancy was a result of a sexual assault. What kind of a sexual assault? Is there a bad sexual assault? Is there a better sexual assault? I don't want to make these decisions. I don't want to make these decisions for my constituents and for the public of Pennsylvania. And I don't believe that citizens in Pennsylvania want me to make those decisions for them. I also would like to address the question of parental consent, which we will debate later under some amendments. The so-called self-styled pro-life caucus has tried to give the public and the rest of our colleagues...
Will the lady suspend?
Certainly.
The question is on the amendment. We are only permitted to discuss the amendment that is before us and the amendment before us, not amendments that will be taken up later in the afternoon. The lady is in order to continue on the amendment.
Thank you, Mr. Speaker. I stand corrected. I also do not want to characterize any person here or to get personal with any of my colleagues. But I wish you would look at this amendment carefully and see with me that it really is a terrible insult to the women of this state and their families. And I am sorry again to hear the maker of this amendment go through a description of the medical procedure that we're talking about. Medical procedures are not pretty. None of them are. This procedure is not pretty. I have known people, indeed, to faint at childbirth. This is no reason for discouraging childbirth. I think that this legislation assumes that women are too foolish, too silly, too evil, too immature to understand what they are doing. I do not believe the women in Pennsylvania are too evil, too silly, too immature, or too foolish to make this decision on their own. When we are talking about prohibiting sex selection, abortions, I believe the amendment says, you women don't understand how serious this decision is, so we'll tell it to you for you. I don't believe that women in Pennsylvania trivialize this decision. I don't believe they're frivolous, and I have trust in them. I think the public understands. The question is, who decides? I urge you to have faith in the people who sent you here and who pay our salaries. And I urge you to vote no on this amendment.
Ayes and nays will now be taken. Members will proceed to vote. Members must indicate to the chair their seeking of recognition. The chair checked every microphone, and no one was seeking recognition when he called for the vote. Strike the vote. Clerk will strike the vote. Speaker would like to impart some information to members of the House. We are in receipt of some 80 or more amendments to the legislation before us today. The minority leader early this morning indicated to the House, and the majority leader, that we would get through the legislation before us if members were succinct. I'm not sure what that means, but I'm sure that we are not being succinct. Question is on the amendment. On that question, from Allegheny County, Representative Itkin is recognized.
Mr. Speaker, I apologize to the House for the long day that we're apparently going to be faced with. I'm sure most of us feel that we'd prefer not to address this issue and somehow have it go away. I certainly would subscribe to that. And I didn't bring this issue before this House today. Others did. I am concerned, however, the manner and the extent to which the measure that we are now considering will affect the people of Pennsylvania. And I am concerned about the continuing erosion of what I perceive are constitutional protections and freedoms guaranteed to every American. You know, many of us are concerned about the American flag, and we wish to see it kept whole and untarnished. But recently we've been seeing the fabric of our Constitution teared. And unfortunately, too many of us don't seem to respect or recognize that fact. You know, we took an oath to uphold the Constitution of Pennsylvania, United States, and to not to support those measures which violate those sacred documents. And if you don't believe the Constitution of the United States is a sacred document, then you ought not be here. Because we are the ones that represent our constituents, and in fact, if we believe that something ought to be changed and it's not in the Constitution, then we have a procedure to change that Constitution. Mr. Friend, in the offering of his amendment and discussing the amendment, stated that his amendment did not reverse Roe versus Wade, and that that decision still held. Now, I am not a legal scholar, Mr. Friend. I'm not even an attorney. I'm a scientist by past practice, but I can read the English language, and I've been trying to understand how your amendment does not violate the Constitution of our country. And if the House will only give me a few minutes to provide you with the documentation, I think it'll become clear that the Constitution of this is being violated by this amendment. We have in 1979, the Supreme Court in Colati versus Franklin stated, determination of whether a particular fetus is viable is and must be a matter for the judgment of the responsible attending physician, and state abortion regulation that impinges on this determination, if it is to be constitutional,
Mr. Speaker, point of order.
Must allow the attending physician the room he needs to make his best medical judgment.
Point of order, Mr. Speaker.
Gentleman, Mr. Gallen, for what purpose the gentleman rise?
Mr. Speaker, if the gentleman wants to discuss constitutionality, he should raise that question, and we're not on constitutionality.
Mr. Speaker, I am...
The gentleman may discuss whether the issue before us is constitutional or not constitutional, and raise the question or not raise the question as he chooses. He is debating the amendment.
Thank you, Mr. Speaker. The court went on to say, since the point of viability may differ with each pregnancy. And this is the Supreme Court, not a lower court speaking. Neither the legislature nor the courts may proclaim one of the elements entering into the ascertainment of viability, be it weeks of gestation or fetal weight or any other single factor, as the determinant of when the state has a compelling interest in the life or health of the fetus for purposes of regulating abortion. And in 1986, the court went on in Thornburg versus the American College of Obstetricians and Gynecologists to reaffirm this Coletti decision. And to the best of my knowledge, the Webster decision did not address this issue. And so the constitutional point is that this legislature may not prohibit abortion before viability. And the insertion of a period of time of 24 weeks strikes in the face of the constitutional language and the opinion rendered by the majority of that court in handing down the decision affecting abortion. Consequently, the issue here is not one of whether Mr. Friend is right or wrong, or whether those that subscribe to Mr. Friend's position is the better public policy. It is on its face unconstitutional, and until the Supreme Court rules otherwise, we are bound by its decision. Consequently, Mr. Speaker, I will now make a motion that this bill is unconstitutional and ask the House to declare itself that the bill is unconstitutional and declare it to be null and void. Thank you, Mr. Speaker.
Gentleman from Allegheny County raises for the House's determination the question of whether or not the amendment offered by Representative Friend is constitutional. The House must decide the question of constitutionality. It is a debatable issue, and the issue is whether or not the amendment before us is constitutional, and all further debate at this time must be directed to constitutionality. Gentleman, Mr. Friend, on the question of constitutionality.
Thank you, Mr. Speaker. Before I begin, a point of parliamentary inquiry.
May I state the point of parliamentary inquiry?
I forget, but I believe it's the question when we vote on it will be couched in is it constitutional or not. So a yes vote says it's constitutional, a no vote it's unconstitutional. Is that correct?
That is correct.
Thank you, Mr. Speaker. I rise to ask for a yes vote. Very briefly. The governor, as you well know, has always had a concern about constitutionality, as I well know. The governor and his office strongly believe, and one can make a compelling argument, that even if the court hadn't changed, these provisions are constitutional. Remember what Roe versus Wade said. And what it said was that abortions which are necessary are permitted. And so the issue comes down to what is a necessary abortion. It strikes me, for example, that even the old court would find that it is not a necessary abortion to have sex selection, that it was not an infringement on an abortion to have informed consent, that in fact an abortion after 24 weeks, except to save the mother's life or to avert substantial and irreversible impairment of major bodily function, can never be considered necessary. So there's a framework right now where, in fact, each provision could be ruled constitutional. Remember this, however. Simply stated, when you cut to the chase, constitutionality is what 5 or more justices of the United States Supreme Court at any given time say it is. In 1973, 7 justices said it was not constitutional to outlaw abortion. We've seen that change. We have read the opinions in Webster. We have read, for example, Justice Scalia's opinion that says flat out Roe ought to be reversed, and the other opinions that question Roe. The only way that that issue can be resolved is to permit the court the opportunity to once again review legislation. Under the rationale to do nothing and never change once a court comes down, we would be stuck with the decision of the United States Supreme Court in 1857 in the Dred Scott case that said that slavery was legal, that it was institutionalized, that a slave wasn't a citizen, and we weren't sure whether or not a slave was a human being. Plessy versus Ferguson, separate but equal. All of the inroads we've made on civil rights and a host of other areas. What the argument seems to be is stand with our feet in concrete. I think it's a bad idea. I think this is constitutional. I ask for a yes vote.
Question is whether or not the amendment offered is constitutional and can be considered by the House. And on that question, gentleman from Cumberland County, Representative Broges.
Mr. Speaker, the Speaker, Representative Friend, was incorrect when he said that Roe v. Wade did not discuss or, in fact, held constitutional the provision on sex. Roe v. Wade said, in the first trimester, the attending physician, in consultation with his patient, is free to determine, without regulation by the state, that in his medical judgment the patient's pregnancy should be terminated. If that decision is reached, the judgment may be effectuated by an abortion free of interference by the state. That section, with respect to sex determination or having an abortion only for sex, regardless of what you think of it as a policy matter, good or bad, and I believe that it should not be, there should not be an abortion, is in fact covered by Roe, and Roe said that there shall be abortion in the first trimester without regulation by the state. In fact, this question was not faced by the Webster decision, and in fact, Webster said Roe was not overturned. In addition, on constitutionality, on the Act, in the Abortion Control Act of 1982, there were about 7 requirements for informed consent. Those 7 requirements were stricken in Thornburg versus American College of Obstetricians in 106 Supreme Court. It was found unconstitutional. It is only the hope of Representative Friend that this court will reverse it. He spoke of Roe v. Wade being decided in 1973. Well, he's correct that there were different justices in many respects and beliefs, and that it was a long time. But in fact, the Thornburg decision was in 1986, 3 short years ago, and it was a unanimous court of 9 justices that decided that. So it's not a new court. It's not what this court today says it is. It is a question of respecting the decisions of the court and respecting Webster when it says Roe v. Wade was not overturned in this regard. So there are many unconstitutional provisions in Representative Friend's bill, and you should consider that in your deliberation. Thank you.
The question is on the constitutionality of the amendment. On that question, Representative Itkin from Allegheny County.
Mr. Speaker, the gentleman from Delaware County, Mr. Friend, mentioned the abortions are not offered on demand and must be necessary. However, the current law talks about necessary as being the clinical judgment of the physician, not by the state. And that's the way it should be, Mr. Friend. The woman, in consultation with her physician, ought to make that judgment, and the physician ought to use his medical professional judgment as to whether the abortion is required as any medical procedure. Mr. Friend, you have not cited to me and to this House any rational reason, any citation, any language in Webster or any other prior determination of the Supreme Court that countermands the language that I mentioned as written opinions by the Supreme Court of the United States. I mean, I would like to be educated. I ask you right now, please cite to us here in this House the appropriate section of some majority opinion of the Supreme Court that says, yes, with respect to the 24-week point on viability, here is what it says. I wait your answer, Mr. Friend.
Is that a question?
Request for
That's a
interrogation? Will the gentleman consent to interrogation?
One doesn't have to be a math genius to be able to count
No,
up
don't pay
to
any
9.
attention to me.
Pardon me?
The gentleman indicates he will consent to interrogation.
Oh. Thanks, Mr. Speaker. To the contrary of what Mr. Bruges said, Thornburg in '86 was 5-4. Justice Sandra Day O'Connor coming down on the side of the constitutionality of that statute. That was at a time that Justice Kennedy, in fact, was not on the court. If one looks at the language, for example, and the court places Colati right in there with Roe versus Wade, the Rehnquist opinion, there is no doubt that our holding today will allow some governmental regulation of abortion that would have been prohibited under the language of cases such as Colati v. Franklin and Akron v. Akron Center for Reproductive Health. That's just one quote. In fact, those opinions are replete with statements by 5 justices that, in fact, legislative bodies are now permitted to do things that they couldn't. And as a matter of fact, those opinions, in addition to the strict opinion by Justice Scalia that said, let's overturn Roe now, but the opinions of the other 4 justices contain very direct invitations to legislative bodies to do precisely what we're doing right now, to provide at least one provision that gives the court the opportunity to once again look at Roe and give it the opportunity to overturn Roe or to continue the erosion process begun under Webster. Under your rationale, Mr. Speaker, we would have had no advances whatsoever in the last 200 years in issues such as slavery, civil rights, and a plethora of other issues. Thank you.
So, Mr. Speaker, the answer by the gentleman from Delaware is that we will pass today an unconstitutional act in violation of our oath in the hopes that perhaps by inferences that some members of the court, of the Supreme Court, may change their mind later on, or in fact, when the issue comes to the courts 2 or 3 years from now, it will be adjudicated as being constitutional. Right now, the law of the land is the Supreme Court's current determination. That is what we are bound to abide by. That is what we took an oath to uphold, not the fact that we will pass an unconstitutional law and hope that a favored president might anoint a member to the court who might see the Constitution in a different light. Mr. Friend, whether it be 9-0 or 5-4, that's the way our government and that's the way the laws of our land work, by a majority. And I say to you again, Mr. Friend, that the language you have presented to the House today is patently unconstitutional. You have made no reference to anything to cite to the contrary, and I hold it out to my members here that the only cost of action for us to be constitutional is to vote in the negative on the constitutionality motion. Thank you, Mr. Speaker.
Question is on whether or not the amendment is constitutional. On that question, Representative Heckler.
Briefly, Mr. Speaker, 2 points. Upon earlier interrogation, the maker of this amendment suggested that we're engaged in this exercise as a response to Webster, that Webster articulated a new test, a rational basis test. I would suggest to you that only 4 of the 9 justices adopted such a standard, that in fact Justice O'Connor and the dissenting justices adhered to the strict scrutiny standard and in fact decided Webster on that basis. Secondly, I wouldn't have believed it, but I actually dug through the back memos that we've all received from the maker of this amendment, one of which acknowledges, just as the Speaker has, that the whole exercise we're engaged in is to propound provisions which challenge Roe. I would submit to you, and I have no illusions about how this vote's going to go, but I would submit to you that the whole purpose of this exercise is to provide a vehicle to challenge Roe, and that the legislation we're about to vote on is not constitutional. Thank you.
Question is whether or not the amendment is constitutional. Those believing that the amendment is constitutional will vote in the affirmative. Those believing that the amendment is not constitutional and therefore out of order will vote in the negative. Members will proceed to vote. Have all the members present voted? Have all the members voted? The clerk will record the vote. On the question of constitutionality, the yeas are 142, the nays 59. The House has determined that the matter before us, the Friend Amendment, is constitutional and in order. The question is on the Friend Amendment. On that question, from Lancaster County, Representative Brandt is recognized.
Thank you, Mr. Speaker. After serving quite a few years in this chamber, no vote have I come to the floor on till this time realizing how I was going to vote. I read with interest and reviewed all the information we received on this issue from both sides, and listened to the debate very closely between Representative Friend and Representative Ritter. And previously, I was voting for the personal choices of women. And on the main on looking at the Representative Friend's amendment, in individual sections, one could possibly support them. However, Mr. Speaker, I feel at this time, we once again on this House floor are attempting to legislate a medical decision, and I urge you to vote against the Friend Amendment.
Question is on the amendment.
Mr. Speaker.
From Allegheny County, Representative Farmer.
Thank you, Mr. Speaker. Mr. Speaker, I'm hearing on both sides of this issue general agreement with respect to some restriction on abortion after the viability of 24 weeks. But I've had many people in my district, Mr. Speaker, who've contacted me who felt that the subject of abortion is a very private matter that should not be decided by government. And these concerned citizens in particular felt that in Section 3209 of Mr. Friend's amendment that the spousal notice, for example, was a prime example of unneeded governmental intervention in the daily lives of these residents. While I oppose the spousal notice portion of this bill, I am in agreement with Mr. Friend on many other sections of his bill. I'm disappointed that our process today with amending a Senate bill will put the cart before the horse. In other words, Mr. Speaker, that we must address the entire bill first before we have the opportunity to hear what types of amendments will be offered to deal with this invasion of privacy. And for that reason, Mr. Friend, I will not be with you on your first vote. Thank you kindly.
Question is on the amendment, and on that question, from Allegheny County, Representative Olass is recognized.
Yes, Mr. Speaker. Death is not denominational, nor is it the opinion of any individual where the real issue of abortion is concerned. Abortion is wrong not because the representatives of any religious denomination or individual say so. It is wrong because it kills innocent human life. I believe an unborn baby is a human being. This belief transcends any religious affiliation, regardless of what any court or any individual may say. A human being is entitled to life and deserves the protection by law. Abortion violates the most basic human right, the right to continue living once you have begun to live. Regardless of your position, in conscience, you must face the question, the medical question, as to when life begins. We're told that modern biology teaches that ancestors are united to their descendants by a continuous material link. It is from the fertilization of the female cell by the male cell that a new member of the species will emerge. Life has a lengthy history, but each individual has a specific beginning, the moment of conception. The material link is the molecular thread of DNA. In each reproductive cell, this ribbon, approximately 1 meter long, is cut into pieces, 23 in our species. Each segment is carefully coiled and packaged like a magnetic tape and a mini cassette, so that under a microscope it appears like a little rod, a chromosome. As soon as the paternally derived chromosomes are united through fertilization to the 23 maternally derived chromosomes, the full genetic information necessary to express all the unborn qualities of a new individual is gathered. The complex new human being begins to express himself or herself as soon as conception has taken place. The human nature of the human being from conception to death is then a conclusion of medical science. I've heard a lot of comments about a woman's right to choice, and especially in a marriage, that a woman has the right to withhold information from her husband. Small wonder that we have such chaos in the world today. I can't imagine any union surviving when a wife withholds information from her husband. Let's paint the worst case scenario. Somehow she contracts a venereal disease. She's not going to tell her husband? Is that socially responsible? Small wonder there's chaos in the family and children look and question at their parents. On a matter of choice, and this will probably bring a lot of boos and hisses, but I went to one of our neighborhood pharmacies this week, and on the shelf I counted 50 choices in a way of different condoms. I counted 18 different choices with sponges, gels, foams, you name it, it's there. But apparently the most appealing today is abortion. That seems to be the best control for the abortion.
Will the gentleman suspend? Will this House please be in order? For members of the videotaping crews that are on the floor of the House, your privilege on the floor of the House extends to using the video camera without disturbing members or without talking to members. Please comport to that rule. Gentleman's order may continue.
Does a woman have the absolute right to control her body? For that matter, does any person, man or woman, have such a right? If so, then a person has the right to damage his or her own body with drugs or alcohol, even destroy the body by committing suicide. When abortionists speak of a woman's right to control her own body, they overlook the fact that in every abortion, we're dealing with not one body, but with two separate and distinct bodies. Removing and destroying a fetus from a woman's body is not the same as removing or destroying a tumor. If you disagree that life begins at conception, please explain just when life begins. The right to life is the most basic of all human rights, and without it, all other rights are meaningless. The unborn infant, as a child of the Almighty, possesses this basic right and it should be protected by those in a position to do so, since a helpless infant is not in a position to protect himself. Think about it. Just last week, Mr. Speaker, we spoke about pigeons and we spoke about AK-47s. I think the AK-47 that we're talking about today is a weapon of abortion. The world gets uptight when, unfortunately, 6 children or so are murdered in a schoolyard. How about the millions that have been murdered by the AK-47 of abortion? We're concerned about wringing the neck of a pigeon. How about the crushing of a skull of a poor baby that's defenseless? Think about it and then vote your conscience. Thank you, Mr. Speaker.
Question is on the amendment offered. On that question from Chester County, Representative Taylor.
Thank you, Mr. Speaker. I will be brief. But it does appear to me that we have left out of this debate the overwhelming number of women, mothers-to-be, and young women who stand firmly, lovingly, and knowingly for the protection of the unborn and for the abolishment of abortion on demand. And so, therefore, representing those women, I urge a yes vote.
Question is on the amendment. From Montgomery County, Representative Simon is recognized.
Thank you, Mr. Speaker. Very briefly, I rise to point out a dichotomy of procedure that we're involved in, was alluded to by Representative Farmer. We're being asked to vote on an amendment that admittedly we already have 80 additional amendments to. We're asked to vote now, yes or no. At the conclusion of today, hopefully, there will be some decision on those 80 amendments. If they are all no, and someone has voted in the hopes because there were certain parts of the Friend Amendment that they support, but only to find that all of them have been defeated, they will then have voted a yes vote without it being the vote that they really wanted, simply to get those amendments in place. I think that this complicates our voting procedure. I think that it should be read into the record that this is what we are faced with at this time and this particular vote about which we are now asked to cast. Thank you.
On the amendment, yeas and nays will now be taken. Members will proceed to vote. Have all members voted? Have all the members voted on the amendment? The clerk will record the vote. I wouldn't announce it if you didn't.
No, I talked to you.
On the question of the House adopting the amendment, the yeas are 143, the nays 58. The amendment has been adopted. The question recurs at this time, will the House agree to the legislation before us with the amendment attached? On that question, from Montgomery County, Representative Haggerty indicates there is a further amendment to be offered. The clerk will read the Haggerty amendment.
It's Amendment A 3430. Amend Section 4, Section 3216, page 10.
Question is, will the House agree to the amendment offered by Representative Haggerty? Will the House please be in order? On that question, Representative Haggerty.
Thank you, Mr. Speaker. Mr. Speaker, I rise today to offer an important amendment on behalf of the Juvenile Diabetes Foundation. The Juvenile Diabetes Foundation is a voluntary health organization of over 160 chapters dedicated to furthering research towards a cure for diabetes and to improving the quality of life of the diabetic. The Juvenile Diabetes Foundation vehemently opposes a ban on research on fetal tissue. The Juvenile Diabetes Research Foundation contacted me, guess when this legislation first became public, to express their concern. That promising new research to help cure juvenile diabetes would be threatened by this legislation. They related to me, and I relate to you, this promising research. In recent years, the possibility of transplantations of pancreatic tissue from fetuses has been used successfully in order to reduce the insulin dependence of juvenile diabetics. There are currently at least 30 people in the United States who are living with fetal pancreatic transplants. Researchers are optimistic that many of these patients will experience a reduction in insulin requirements. In addition to the Juvenile Diabetes Foundation, I have learned that there is research ongoing in other areas, such as cancer and Alzheimer's disease, with great hopes for reduction in the incidence of these diseases from this research. Recently, a national debate on the scientific, legal, and ethical issues associated with fetal tissue from induced abortions occurred. As a result of this debate, such research was suspended, and a National Institute of Health convened an advisory panel. This National Institute of Health advisory panel was made up of scientific, legal, and ethical experts. They concluded that federal sponsorship of this research should resume, provided that certain safeguards are instituted. These safeguards, which are the content of my amendment, I want to share with you. My amendment would provide that the National Institute of Health research recommendations be put into place in Pennsylvania so that fetal research could continue, but could continue with clear ethical, legal, and moral guidelines. And let me tell you, because if you look at the amendment, because it's drafted to Steve's language, it won't be that clear what these standards are. So I want to read to you what exactly the amendment provides. Number 1, the decision to terminate a pregnancy and the procedures of abortion, including timing and method, should be kept independent from the retrieval and use of fetal tissue. Number 2, proper and informed consent should be obtained from the pregnant woman. Further, the process of obtaining informed consent from the woman should be deferred until after the decision to abort has been made. Payments and other forms of remuneration and compensation should be prohibited, except payment for reasonable expenses occasioned by the actual retrieval, storage, preparation, and transportation of the tissue. Number 4, potential recipients of fetal tissue, as well as any and other all participants, including researchers, hospital personnel, and others, should be properly informed as to the source of the tissue in question. 5, procedures must be adopted that accord human fetal tissue the same respect accorded other cadavers. And 6, the pregnant woman should be prohibited from designating the recipient of the fetal tissue. The amendment that we have just passed does contain language allowing for fetal tissue research. The problem is this language, which many of you may believe is the National Institute for Health, Language, and Standards, is not. My amendment reflects the National Institute for Health standards. The problem with the amendment's research and standards is as follows, and I refer again to the juvenile diabetes analysis of it. Steve Friend's amendment says that the National Institute for Health standards are minimal standards. It requires our Pennsylvania Department of Health to promulgate further regulations. The fear is that those regulations could in fact implement a moratorium on such transplantation research. Further, the language in the Friend Amendment provides that in promulgating these regulations, there is language that looking to preferring childbirth over abortion, an issue which has nothing to do with fetal research. Fetal research does not begin until after the fetus is no longer living and is removed from the mother. An additional problem with this language is that the consent that Representative Friend provides for cannot be obtained until after the abortion is done. This is a problem because of timing. I am told that the timing involved at this point is critical, and the protocol in order for the tissue to be usable is such that there cannot be delay after the abortion. An additional problem with Representative Friend's amendment is that it does not allow for any transportation expenses occasioned by the actual retrieval, storage, preparation, and transportation of the tissues. I urge you, if you believe that research should continue to help cure juvenile diabetes and other diseases, that you support this amendment, which I'm offering in accordance with the National Institute of Health guidelines. This is the only amendment that those people doing the research in the field and representing these groups believe will ensure the ethical, proper continuation of research. Thank you.
Question is on the amendment offered, and on that question from Philadelphia, Representative Kozinski is recognized.
Thank you, Mr. Speaker. Would the representative from Montgomery County stand for interrogation?
Yes. Yes.
Mr. Speaker.
Lady indicates that she will.
Thank you, Mr. Speaker. How many fetuses are needed per successful treatment of, let's say, an insulin patient, a diabetic patient?
Well, I don't know. My understanding of this procedure is that the tissue is used from the pancreas and that tissue is transplanted. I'm not aware of any specific number that would be needed.
Mr. Speaker, on the amendment.
You are in order. May proceed.
I rise against the Haggerty Amendment, and I do so with some trepidation, because this is an emotional issue that may affect me someday. I may, in fact, be diabetic at some point in my life. It runs in my family, and I have vacillated on the issue, and for the members who know me very well, I very rarely vacillate on anything. I have wrestled with this, and it's only through information that has been given to me over this past weekend that I've decided to go against the Haggerty Amendment. First of all, you must understand the mindset. The people who are talking about a cure for diabetes and a cure for Parkinson's disease are advocates of this because they are holding out hope that this will be the cure. This is not a cure. It is only in the experimental stage. The results so far have been mixed. In some cases, due to the degenerative condition of diabetics, people have gotten worse with this treatment. Some have shown slight improvements. Others have received other complications. So this isn't the cure-all that the advocates push or may want you to believe that it is. Let's talk about the issue of harvesting. Let's face it, when the fetus is aborted, and we're talking about not spontaneous abortions here, but induced abortions, that fetal tissue must be fresh. In many cases, that unborn child may still be alive when aborted. So we are dealing here with fresh tissue. Now, Representative Hagerty refers to the NIH study, and in that study, I'm going to go by the dissent, that to cure or possibly cure, because again, it is very speculative as to the cure, to treat 10,000 insulin patients, you may need between 300,000 and 500,000 aborted fetuses. That means that the possible, quote, cure would only be available to a limited number because there are 2 million diabetics in this nation. But my biggest fear is that we've received information from Representative Hagerty about one possible solution here. And we are not talking about other possible solutions that could cure diabetes, could cure Parkinson's disease, and other alternatives that may exist within the next decade. The first would be the use of cultured cells for transplants. There is an autograph, that's A-U-T-O-G-R-A-F, for the people who are copying this down, in which the tissue is transplanted from one part of a patient's body to another. There could be pharmacological treatments, or there could be transplant of tissues from animals, as are currently done in heart valve transplants from pigs to humans. So you have another of other series of treatments which may prove to be more successful than the use of fetuses, of the unborn child, for the treatment. If we take this a step farther, though, and look at the practical matter, the study that Representative Hagerty refers to is currently the source of a lot of controversy in Washington, D.C. The study itself by the National Institute of Health is so controversial that there currently exists a funding moratorium. That moratorium may be continued by President Bush as early as this week. So there are alternatives available as far as fetal tissue is concerned, and I would ask my colleagues to think about this very closely and vote against the Hagerty Amendment.
Question is on the amendment. On that question, Representative McHale.
Thank you, Mr. Speaker. Would the lady, Mrs. Hagerty, stand for a brief interrogation?
She indicates that she will. You may proceed.
Thank you, Mr. Speaker. Representative Hagerty, I was affected in my judgment by your earlier presentation, and I frankly would like to be able to vote for your amendment. Before I do that, I want to clarify some of the language contained in your amendment, and specifically where you make reference to an exception for payment dealing with the actual retrieval of tissue. I would like to make clear, if in fact this is the case, that by actual retrieval, you're not referring to the ordinary fee charged for an abortion service.
No, absolutely not.
What do you mean by that term? Perhaps I can clarify my question a bit. Are you talking about the physical retrieval of the tissue after the abortion?
It would be the physical retrieval of the tissue after the procedure. That is correct. It has nothing to do with the procedure. This is only after the procedure itself.
That satisfies my concern. Thank you.
Question is on the amendment. On that question, Representative Friend.
Thank you, Mr. Speaker. I rise to oppose this amendment.
Will the gentleman suspend? May continue. May continue.
Thank you. I rise to oppose this amendment. As I indicated earlier, 3 or 4 days ago, a number of pro-life legislators came with a serious concern about the state that our bill was in at the time, which prohibited the use of tissue or organs from aborted babies. And I explained to you what their rationale was. Whereas I personally didn't agree, I certainly respected their opinion. And because of that respect, and because for a pragmatic consideration that if you have certain pro-life members who are concerned here, the possibility exists that you could have an amendment which gutted any regulation law and you have nothing, we changed the language. And what we did was put in language which to a large extent is modeled after the recommendations of the advisory panel for the National Institute of Health. We feel that we were open-minded and we made a very important accommodation, one with which I do not philosophically agree. Now, there are 3 major differences between the Hagerty Amendment and what's in the amendment you just passed. Number 1, our language says that the informed consent for the mother or former mother to permit the use of the tissues and organs can only come after the abortion is performed, and there's a reason for that. We do not wish to have an additional inducement to abortion about the fact, well, that you can use the tissues and organs to do some good. We met yesterday with a member of that advisory panel who voted against the recommendations. He indicated that studies indicate that about 40% of women who have abortions, and even more, will change their mind 2 or 3 times, are weighing back and forth considerations whether or not to have an abortion. Now remember I said that abortion clinics, to stay in business, have to perform abortions. If they don't, they're out of business. It's that simple. If in fact they can obtain that informed consent to use the tissue before the abortion, there's really no adequate safeguard to ensure that that argument isn't mingled in with the informed consent as to whether or not the woman should have an abortion. Secondly, we completely ban any form of remuneration. We don't want to have a business of the selling of aborted babies' parts. What the Hagerty Amendment does is also ban remuneration, but says except that payment for reasonable expenses occasioned by the actual retrieval, storage, preparation, and transportation of the tissues is permitted. By definition, the only way these research organizations can get the job done anyway is to be physically at the abortion clinic prior to the time the abortion is performed. They have to be there anyway. There's no need for reimbursement for any expenses to the abortion clinic. And notwithstanding the interrogation of Mr. McHale and the answer by Mrs. Hagerty, when you look at that word retrieval, what you have done is open up a loophole about 50 yards wide to permit these organizations to pay the clinics for the performance of an abortion, because there is no way you can retrieve the tissue and the organs until you kill the unborn baby. We have specifically cut off funding, state funding, for all abortions except life of the mother, rape, and incest. Overwhelmingly, we've done that. What we're doing here is taking a massive step backward. The third thing that we do is require the Department of Health to promulgate these specific regs and give them latitude to continue to weigh the developments and the additional disclosures on the federal level, to make a decision as to whether or not they wish to change them, alter them, add or delete. We think the Department of Health, charged with this responsibility, should have that responsibility right now. Excuse me. We have bent over backwards to accommodate good faith members who are strongly pro-life on this issue. We think the existing language does just that. We think this amendment is dangerous for the reasons that I set forth, particularly because of that retrieval language can open it up to have these groups pay the abortion clinics for abortions. I sincerely hope we vote no. Thank you, Mr. Speaker.
The chair recognizes the Republican leader, Matthew Ryan, from Delaware County.
Thank you, Mr. Speaker. Mr. Speaker, I guess I'm one of the members of the House that Representative Friend referred to when he said he was approached by pro-life legislators with certain problems that they wanted to address in this bill. I did have such a meeting with Steve Friend and frankly thought that we had worked this out. A number of us, particularly from my county, were approached through the mails by a man that we all knew and have a great deal of respect for, who has a child with juvenile diabetes. And he is on the board, apparently, of the Juvenile Diabetes Foundation. And in his letter to us, he pointed out that all of the things that he is interested in life, which we know him for and what he stands for, really are of no moment next to his concern for his child. And he goes on to point out that his hope and aspirations for the good health of this child really rest with the research and experimentations that are being carried on by medical schools and in particular being carried on under the auspices of the Juvenile Diabetes Foundation. And they sent to us copies of the legislation they would like to see adopted, which represents the legislation in the words of the National Institute of Health. And the amendment that the lady from Montgomery, Mrs. Haggerty, offers does reflect, in conjunction with the language that's presently in the bill that Mr. Friend saw to was added to the bill, would then reflect the words that the Juvenile Diabetes Foundation and the National Institute of Health believe are proper to cover this subject. I listened to Mr. Friend say that he had met with and talked to a member of the National Institute of Health team that adopted certain regulations and recommendations, and that this man was a minority viewpoint. Well, that man I also talked to yesterday, he's also the attorney for the pro-life group, so that he's not completely unbiased when it comes to this subject, and I think that should be made clear that he expressed the views of the National Pro-Life Group. I think what bothers me the most about the situation we find ourselves in is that today there is no prohibition against using these fetuses for research, and this is a tough subject. I mean, I frankly have a great deal of trouble discussing it because I think it is something that's personal, and I'm not trying to in any way downplay the seriousness of the subject matter. So if I use words perhaps that are offensive, I apologize in advance. It's not intended to be offensive. But today, a person has a miscarriage or a therapeutic abortion. That fetus can be used under this bill as it's presently before us for research purposes. It's the abortion which would be legal. That's the part that bothers me. It would be legal under this bill to have an abortion, but those fetuses that result from that abortion would not be available for medical research. Now, we have heard, information has been passed to us that 7 of the medical colleges, I believe all of the medical colleges in Pennsylvania, have gone on record stating that they want and they approve and they recommend to us that it is absolutely vital that this be available to them. And I'm going to read just a paragraph or so from a letter signed by the heads, I believe they're the heads of each of these 7 university medical schools. And in the second paragraph of a letter addressed to Representative Ritter, dated October 17th, it says, major advances and breakthroughs in a number of health care problems, and it's more than just juvenile diabetes, are related to research utilizing fetal tissues. These include diabetes, metabolic diseases of the central nervous system, such as Parkinson's, inherited blood disorders, vaccine development. It's also being used in connection with research in cancer, AIDS, pulmonary, kidney, eye, and dental diseases, as well as previous research leading to a better understanding of aging and vaccines against rabies and rubella and certain congenital abnormalities. Well, a woman's decision under our law to have an abortion is I'm guessing, I believe, a tremendously traumatic decision that they've made. Having made that decision, this bill, as amended by Representative Hagerty, would permit that person, having made the decision, would permit that person to allow the aborted tissue to be used in connection with medical research that may help any number of children in the future. Now, I listened to the gentleman, Mr. Kaczynski, and he said there are other alternatives. Well, I'm sure there are other alternatives to the Salk vaccine. They could have looked somewhere else, and to any other areas of medical research. The fact remains, the hospitals that you and I fund every year, the medical schools that we fund, the people that we put the most trust in connection with our medical lives, they're telling us that we're making a mistake if we deprive their research teams of the availability of this tissue. Mr. Speaker, I strongly recommend that this House adopt the Hagerty Amendment. Thank you, sir.
On the question of the amendment, from York County, Representative Bortner.
Thank you, Mr. Speaker. I would like to follow up on some of the comments of the minority leader and speak in support of this amendment. And regardless how members feel about this issue overall, and regardless of how you may consider some of the other amendments, I hope you will consider this issue and this vote separately, because I think it is different. I'm not going to even argue to you the effectiveness of the treatment or the research or go into some of the medical considerations that Mr. Ryan did. Instead, I'd like to just appeal to your logic. Currently in Pennsylvania, a parent can donate an organ from a deceased child. Mr. Ryan pointed out that miscarriages, tissue can be donated for research. Currently, a parent could donate the cadaver of a deceased child, and that is all regulated by current Pennsylvania law. Why shouldn't we allow the parent or the parents in a situation where, as Mr. Ryan stated, the very difficult and traumatic decision about having an abortion has been made, give that same parent or parents the satisfaction of knowing that they may be able to help other children by using that fetus for research or for treatment. If you're really cynical about this issue, I suppose you might argue that this encourages people to have more abortions. I don't think you can reasonably make that argument. I would urge all members to do what I believe is the humane thing to do and to support the Hagerty Amendment. Thank you.
On the amendment from Allegheny County, the chair recognizes Representative Levdansky.
Thank you, Mr. Speaker. Mr. Speaker, I rise also in support of the Hagerty Amendment. I would also like to take this opportunity to clarify a couple remarks that was made by one of the previous speakers in opposition to the amendments. In his comments, Representative Kaczynski mentioned that there were other alternatives available to do research into quote-unquote cures for diabetes. To my knowledge, and I've spent some time studying the issue of diabetes because it's affected my family directly, I am not aware of any cure for diabetes. There is no cure presently on the market for diabetes. 300 to 500,000 pancreases are not readily available to solve the diabetes for my two younger brothers. It's just not there. What we're talking about is research very much in the experimental stage. Very much one day could possibly lead to a cure to diabetes. Now, I'm not an expert on the regulations promulgated by the National Institute of Health, and I'm not as well versed about the research as those people at the Juvenile Diabetes Association and the Diabetes Association is. But I can tell you, from my perspective, if permitting research to be done, if permitting the use of the Owls of Langerhans, which are just a cluster of cells in the pancreas, not the entire pancreas itself, but just a small cluster of cells produce insulin that your body needs, if we could promote research that will one day lead to a solution, to a cure for the diabetes which afflicts my brothers and over millions of Americans across the country, if we can do that, I would make an argument that we ought to, and that in fact supporting the Hagerty Amendment is supporting human life. And for that reason and many others, I urge an affirmative vote on the Hagerty Amendment. Thank you.
On the amendment from Northampton County, Representative Grupo.
Thank you, Mr. Speaker. I rise reluctantly to oppose this amendment that has been offered by my good friend and colleague, Representative Hagerty. I have a daughter who is a juvenile diabetic and has been a juvenile diabetic since she was 11 years old. She is now 21 and will be 22 in a few more weeks. I know this is a wrenching type of decision for many of us to make. It is for me, because I know that the experiments that may be conducted could someday save the life of my own daughter. But I know my daughter, and I know that she would not want me to vote for this amendment that would use even one cell from one aborted fetus to save her life. And I'm asking you, the members of the House of Representatives, to think about what we are voting for. We are talking about using human tissue that has been aborted. I believe abortion is wrong, and I believe that it is abhorrent to think that we would use these tissues on the pretext of saving someone's life. I'm asking you, as the members of the House of Representatives, to think about this amendment. It is a serious amendment. I'm asking you on behalf of myself and my daughter that you vote no on this amendment. Thank you.
The question is on the amendment And on that question, from Allegheny County, Representative Olaz.
Yes, Mr. Speaker. Like my colleague, Representative Grupo, it's a particularly tough decision to make. It's natural for one to rejoice when you think you've found a cure for Parkinson's or diabetes.
Oh, there it is.
That is until you think that someone has to die prematurely in order for you to secure this life-giving method. I certainly would not want one of my future grandchildren to have to die in order that I might live. What I'm concerned is one that was shared by Professor Ripken of one of the economic schools of thought, that we're getting into a generation of harvesting spare parts. When you think of the possibility of women being exploited, in particular in the third world, solely for the purpose of generating spare parts, one has to question the value that we're putting on a future life as opposed to taking one life. We had it argued during the Nuremberg trials that the experimentation that took place in Nazi Germany, and the attitude was, well, so what? They're going to die anyway. But I don't think that's the proper answer. Unfortunately, the court ruled that that was not proper. Something for all of us to consider. We all relish the day when there can be miracle cures for a lot of diseases that decimate our families. But the question is, at what expense? Should some aborted fetus or some premature death have to occur in order to provide the medical cures? Think about it.
On the question of the amendment from Philadelphia County, Representative Bishop.
Thank you, Mr. Speaker. I rise in support of the Hagerty Amendment. I rise as a mother of a diabetic son who's been a diabetic since he was 9 years old. He is now 24. And every day we live in hope that there will be a cure someday, or that there will be something that will ease the suffering. And every day there are millions of people who are living under the same hope that there is a door that is open to them. And I beg this House this afternoon not to close that door, to vote for the Hagerty Amendment that will allow the fetus to be used in help and in a cure for those who are suffering from diabetes. Someone made the statement that why should one die so that another might be helped? And I say to you, it is already aborted. What harm can come from using it to benefit those who are asking for prolonged life? So I ask each and every one of our colleagues here, my colleagues this evening, to vote for the Hagerty Amendment to extend the lives of the diabetics who are already suffering, and there is no other alternative. It is the only alternative that they have for a cure. Thank you.
From Bucks County, the chair recognizes Representative Clymer.
Thank you, Mr. Speaker. Mr. Speaker, I rise in opposition to the Hagerty Amendment. Further experimentation by the medical schools will put more pressure for more abortions, which will undoubtedly put more of our unborn at risk. Mr. Speaker, I oppose the amendment. Thank you.
On the question of the amendment from Chester County, Representative Pitts.
Thank you, Mr. Speaker. I think we need to realize we're not talking here about banning. That debate will come later on another amendment. But we are talking about opening a huge loophole in the accommodation that Steve has already made in this bill. We're talking about doing away with state regulation as far as experimentation is concerned. What kind of experiments are we talking about here? We're not just talking about juvenile diabetes. What is the legitimate state interest in regulating experimentation? We do have an interest in ethical medical research. We're not interested in unethical research being conducted. Remember, we're talking about organs from little babies who've been aborted. Now, you can't transplant dead tissue. When your tissue dies, when you're dead, you can't rejuvenate that. We're talking about live tissue, what they call fresh tissue. We're talking about taking a little baby who has been aborted, taking an organ, a pancreas, or a brain, or a pineal gland out of these little babies who've been aborted, and then trying to transplant them. The danger here is the complicity that this amendment will set up between the researchers and the abortion clinic. We're talking about abortion clinics for money providing baby parts to these people on site necessarily, because they've got to have fresh tissue. Mr. Speaker, this is a huge loophole that will come back to haunt us, and I think we should defeat this amendment. Thank you, Mr. Speaker.
The question is on the amendment. On that question from Montgomery County, Representative Simon.
Thank you, Mr. Speaker. Several things have been said which have been very disturbing to me. First of all, the concern for retrieval. I've served for almost 5 years now on the advisory committee to the organ donor committee to the Department of Health. That language, retrieval, storage, preparation, and transportation, is language that is common for the retrieval of an organ in order to see that it is gotten. There's another word that they use called harvesting, and that's a rather unusual term, and we might think of bringing in some piece of equipment. But that's the way they describe this gathering of the organs that are used. Someone mentioned that this is an infant that's been killed, and you don't want to use, therefore, that organ. I would suggest that if someone were shot on the street and brain dead, that we would be delighted to be able to use their heart, their kidney, their liver, whatever, because it's a live organ that can save someone else's life. And because of the purpose or the reason for that death, that doesn't really enter into it. The fact is that that can be used to save someone else, and I have heard many, many family members say it gives some purpose to the loss of the one life. So I think we ought to understand that. To institute what Representative Friend has put into this bill with regard to establishing guidelines by the Department of Health, I would only want to mention one thing. Back in 1982, when we were debating the driving under the influence, there was an amendment offered on this floor to establish quantitative analysis of drugs for determining whether someone was under the influence. And I argued against that, but I'd like to say at this moment that that quantitative analysis still does not exist in the Department of Health. And when Representative Haggerty talks about a moratorium, think about the regulations that have never been written. Think about those that have and the time that it takes. Think then about the lives that could be saved by this research. And think, as you do, that we have here an opportunity to do something worthwhile to support Representative Haggerty's amendment. Thank you.
The question is on the amendment from Philadelphia County, Representative Linton.
Thank you very much, Mr. Speaker. Mr. Speaker, I've heard a lot today about abortion control. Well, the matter before us right now is not an issue of whether or not we support abortion. It's also not an issue of abortion control. The issue before us is whether or not we will allow the tissue from an aborted fetus to be used to prolong, to assist in the life of someone here in this country. It's whether or not we will stand in support of medical research. That's the issue that's before us tonight. We're not here to vote on whether or not we support or oppose abortion. This does not affect abortion control. This is an effort to try to assist in medical research. I cannot see why any member of this House cannot support the Haggerty Amendment. I ask for an affirmative vote on the Haggerty Amendment, Mr. Speaker.
From Allegheny County, the chair recognizes on the amendment Representative Cowell.
Thank you, Mr. Speaker. Mr. Speaker, every time that we vote on the floor of the House on any issue, there's some risk that we're going to cast a vote, make a judgment about something that we're not really very well prepared to deal with. Sometimes that danger is greater than on other occasions. I think one manifestation of that danger is when we come here today and try to discuss what forms of research dealing with juvenile diabetes might offer more hope than other forms of research. I doubt that there's anybody on the floor of the House who is really prepared in a professional way, in an informed way, to make some judgments about that, let alone to lead the debate about it. If there are one or two individuals like that, I think they're the exception. But most of us really are not in that position. And it really would be sad if we try to base our vote today on this amendment on the basis of some belief that one form of research isn't necessarily necessary because there are other options out there, or because somebody has said that it's only research, it's only speculative, and there might be other ways of ultimately saving these lives. Mr. Speaker, I really have trouble believing that those men and women who wrap themselves in the cloak of pro-life activities would today stand in the way of research, stand in the way of possible cures, stand in the way of possible preventions for some of the ills and the diseases that affect hundreds of thousands of Pennsylvanians. And I think it would be the greatest irony of ironies if those who, because of their pro-life activities, because of their pro-life sentiments, today would vote in such a way that they would ultimately allow or perhaps even cause the death of thousands of others. I would urge that we adopt a very reasonable amendment and that we adopt the Haggerty Amendment today.
From Delaware County, Representative Friend.
Thank you, Mr. Speaker. Much of the debate on this amendment has evolved around whether or not the tissues and organs from aborted babies should be used. In this amendment, that's not the issue. The amendment you've already passed, the Abortion Control Act, and the Haggerty Amendment, both permit and regulate the use of these tissues and organs. Very quickly, the three differences and the reason why that I believe what we've already passed is superior to the Haggerty Amendment is this. Number one, we require that the informed consent be obtained after the abortion. We do not want the issue of whether or not to have an abortion to be mixed with the issue of whether or not to donate the organs. Number two, we want to avoid a huge loophole, particularly with respect to the word retrieval, where in fact organizations could be paying abortion clinics who have to stay in business to perform abortions for the performance of the abortions. And retrieval is retrieval. You can't retrieve it unless you abort the baby. Number three, we think this Commonwealth, through the Department of Health, maintains and continues to maintain a legitimate interest in monitoring this extremely complex issue and being able to see the further developments on the federal level. They both regulate, neither prohibit. We think our language is superior. We think we've made a fine accommodation. I would ask for the defeat of the Haggerty Amendment. Thank you.
On the amendment, yeas and nays will now be taken. Gentleman, Mr. Ryan seeks recognition. Is in order.
Just briefly, Mr. Speaker. The principal objection, apparently, of the gentleman, Mr. Friend, deals with this question of payment of expenses for retrieval. Now, as I read the words, it says, no payments and other forms of remuneration and compensation are prohibited, except payment for reasonable expenses occasioned by the actual retrieval, storage, preparation, and transportation of the tissues, which to me says exactly what the lady, Mrs. Haggerty, said, and that is for the actual transportation, retrieval and transportation of the tissue, moving it from one place to another. The law today in Pennsylvania, incidentally, permits this. So this is a dramatic change in the law. Right now, today, prior to the adoption of any new law we might do, what we're suggesting is permitted. That's why these medical schools really are satisfied, I guess, with what we have in the law today in the area of medical research on these tissues. please give a lot of thought to it. I mean, this is the most important single amendment in my judgment, other than the final vote on the bill, and it's the kind of thing that really should cross the pro-choice, pro-life lines. This is a serious vote for the future of an awful lot of people.
Yeas and nays will now be taken on the amendment. Members will proceed to vote. Have all the members present voted? Have all the members voted? Clerk will record the vote. On the question of agreeing to the amendment, the yeas are 122, the nays 79. The amendment has been adopted. And the question is, will the House agree to the bill as now amended? And on that question from Allegheny County, Representative Itkin indicates there is a further amendment. The clerk will read the Itkin amendment.
It's Amendment A 3337. Amend title, page 1, line 6 and 7.
On the amendment, Representative Itkin.
Mr. Speaker, originally I rose to address the question of liability and the question of whether the amendment which was adopted by the House is constitutional. Besides the question of viability, Roe v. Wade also talks about the reasons for having an abortion and what we commonly refer to during the third trimester. As you all know, the requirements for an abortion in that period of time is very, very severe and difficult to attain. In fact, under the current law, of the 50,000 abortions provided in Pennsylvania in 1988, only about 158, according to our state health department, were performed in that particular trimester. Now, the conditions under the current law, which I'm seeking to maintain, allows for the abortion to be performed after viability if the health of the pregnant woman is at stake. As I said before, this is the current law, and the amendment offered by Mr. Friend would delete the health requirement and insert instead a very onerous provision which would have very, very catastrophic requirements on certain pregnant women. And what it says is, in the Friend bill, or in the amendment, that in order to get an abortion, have an abortion performed during this time period, it's necessary for the physician to perform the abortion to prevent either the death of the pregnant woman, which we maintain in my amendment, or the substantial and irreversible impairment of a major bodily function of the woman. Now, we know that this is a very, very difficult health impairment to be able to diagnose. First, the question is, what is substantial? Is not defined. And the question of irreversible is a very difficult question for anybody, including the professional physicians, the experts, to make those kinds of diagnosis. In addition, what is extremely of an extreme concern to me is the apparent attempt to change the knowledge of performing such abortions. A current law states that any person who intentionally, knowingly, or recklessly performs or induces an abortion when the fetus is viable, commits a criminal offense. Now, those three words, intentionally, knowingly, or recklessly, has been deleted from the from the friend language. And all it says is that it shall be a violation if an abortion is performed by a physician, and that physician reasonably believes it's necessary to prevent either the death of the woman or the substantial and irreversible impairment of a major bodily function of the woman. I'd like to ask Mr. Friend a question, and I wish that the gentleman would stand for interrogation.
Gentleman indicates that he will stand for interrogation, and you may proceed.
Mr. Friend, could you inform the House why those three significant words or adjectives, intentionally, knowingly, or recklessly, I guess they're adverbs, performs an abortion, were deleted? What's the reason for that change from current law?
Mr. Speaker, which lines are you talking about?
I'm talking about the current language that you delete, which appears in Section 3210, subsection A, which is current law, and it says any person who intentionally, knowingly, or recklessly performs or induces an abortion when the fetus is viable commits a felony of the third degree. Now, that particular section in your amendment was deleted, was bracketed out, and you have now new language in the viability section.
He wants to know why did we take it.
And in your prohibitions, you replace it with new language, but you delete the term intentionally, knowingly, or recklessly. Do you see that section? And that would appear like on page 7, line 35 of your amendment. It should have been in that. No, it should have been on line 30. Page 7, line 30 should have the language inserted to be consistent with current law.
If I understand your question, the reason why is on page 7 of the amendment under exceptions, we spell out that it specifically will not be a violation of subsection A if an abortion is performed by a physician who reasonably believes that it is necessary to prevent either the death of the pregnant woman or substantial and irreversible impairment of major bodily function. We'll make it very clear we're using the reasonable doctor standard.
Suppose he makes an error of judgment. Would he then be subject to a criminal offense?
Only if the error of judgment were so wanton and willful that it would disregard completely the reasonable physician standard.
So if the physician makes which is I guess a legal standard, an unreasonable judgment, then he can be held criminally for his actions. And what would the penalty for that action by the physician be?
Are you talking about the initial physician in the 24-week section?
Yeah, I'm talking about the physician who performs this abortion and does so unreasonably because he failed to, say, perform a test, or he was reckless, or did something of that, not necessarily reckless, but he did something that was sort of unattentive.
Under the section right now, it's a first-degree felony.
First-degree felony.
Yeah. I should point out that there'll be an amendment run by someone else to make it a third degree, which we will not oppose. But it's a first-degree felony right now.
So you basically elevated the degree of penalty from a third-degree felony, which is in the current law, to the highest criminal penalty the law provides in this Commonwealth.
Mr. Speaker, as I previously indicated, and I'll try to say it again, we think the section we added with respect to exceptions even more so guards the physician.
Okay. Well, I appreciate the gentleman's remarks. I personally interpret that as a certain degree of viciousness, a certain, at least it's going to be a chilling effect on a physician who, when you get close to this question of the 24-week period, and how do you determine precisely what is 24 weeks, whether he should or should not perform that abortion. And also, he has to make judgments. He has to make judgments about irreversible, substantial, major bodily function, all those things. And if he is wrong in his assessment, and reasonably wrong, according to the law, if this amendment is adopted in the bill, we will then, he could be guilty of a felony 1. Now, in addition to that, and I finished with my interrogation, Mr. Speaker, and I have also some additional remarks.
Gentleman is in order.
Mr. Speaker.
Will the gentleman suspend for a moment? The House is getting just a little too noisy. Members are asked to cease their conversations when debate is going on. Will the members please be in order? Will the members take their seats? Will staff that is not required for the debate please withdraw from the floor of the House? You may continue.
Mr. Speaker, I was curious to know, since we have this very simplistic health permission, that if the pregnant woman conceivably has a health problem because of the pregnancy, that in the 3rd trimester she could have an abortion. And I was surprised, and I give you the data, the statistic as well, that only 128 abortions in 1988 were performed out of some almost 51,000. And I ask myself, if getting an abortion in the 3rd trimester is so easy to accomplish, as Mr. Friend believes, why aren't the numbers far greater? And in making this inquiry, by checking with physicians and people who administer and run medical care facilities that provide for abortions, I learned that this is a very serious matter for the woman. Women don't just act after carrying a fetus for 6 months and undergoing all of this discomfort and problems of being pregnant. They don't willy-nilly decide that they're going to have an abortion. It's really serious business. It's serious business between the woman and the physician, particularly with respect to health matters. Now, there are a number of major health problems that can be generated or can be intensified by having to maintain or continue a pregnancy. I'm not going to go further and enunciate many of them, because I can hardly pronounce them, and I don't think that the House really is in a position to listen to all of these medical terms. Suffice to say that there are a number of could the House stand at ease for one moment? Suffice to say, just let me put on the record a couple of examples. Just 2 examples for the reason why women need abortions late in pregnancy and why amendment tries to accommodate this kind of condition. There's one health problem known as toxemia, which is a condition that arises late in pregnancy. And this condition, if not ameliorated, can cause seizures, a stroke, and kidney damage. For those persons, many who suffer from severe diabetes, late in pregnancy can cause a blindness or renal failure. Now, these are just a thumbnail sketch of just a couple of medical conditions that the amendment that we passed would prevent a woman suffering from them from having an abortion and putting that woman in severe health jeopardy. Now, at that point in time, the physician may not be able to say, you know, with certainty that the death of the woman will occur unless he performs that particular treatment or provides that by terminating the pregnancy. Or he cannot say that it may be temporary of very long duration, but not irreversible. And you have to recall that the language inserted by Mr. Friend says if the physician misjudges this, he is guilty of a felony not of the 3rd degree or the 2nd degree, a felony of the 1st degree, just as if that physician went ahead and pulled out a gun and shot his patient in the head. Now, certainly, I don't think that that is a type of penalty we ought to impose upon the medical profession. It certainly will have a chilling effect on physicians who perform this procedure. I mean, that may be the intent by the maker of the amendment, but I think that we should not follow his lead. I think reasonable people can disagree, but I think we ought to accommodate the women of the Commonwealth with respect to their very severe health problems. And I ask the House to support the amendment. Thank you very much.
Question is on the amendment. On that question from Delaware County, Representative Friend.
Thank you, Mr. Speaker. I rise to oppose the amendment. A number of questions were posed by Mr. Itkin. Number one is, why did we choose 24 weeks? Well, we chose 24 weeks for a number of reasons. Number one, we have the information in the brief filed by 167 distinguished scientists and physicians, including 11 Nobel laureates, in support of the pro-abortion side in the Webster case, where they indicate that advances have not significantly changed and the earliest date of viability, which remains approximately at 24 weeks. We also have the statement by Dr. Philip C. Stubblefield, who was formerly the director of the National Abortion Federation, that in fact publications appear to document clearly that viability is possible at 24 weeks. Viability, however, is a relative term depending on the circumstances and where the abortion is going to be performed. We made a decision to pick 24 weeks and say in a reasonable way, after that, no abortions with two reasonable exceptions: the life of the mother, or to avert substantial and irreversible impairment of major bodily function. What the Itkin Amendment would do would not only return us to viability, much less certain, but would also contain the health exception, maternal life or health. And as I've previously indicated, when you have the word health in there, particularly pursuant to Doe versus Bolton, what you have is exactly what we have right now: the ability for a woman at any time in her pregnancy to have an abortion for any reason. Now, Mr. Itkin asked the rhetorical question, why do women have abortions in late terms? I certainly can't answer that. I'm not an expert. But what I do have is the poll which was conducted by the Guttmacher Institute, and that's the research arm of Planned Parenthood. And specifically in the areas of late-term abortion, the issue of health is not even on the chart. 71% did not recognize she was pregnant or misjudged gestation. 48%, these are various reasons, found it hard to make arrangements for abortion, etc. Health isn't even on the chart. If we adopt the Itkin Amendment, we're going back in point and in fact to unregulated, unrestricted abortion at any time in pregnancy, including the very latest stages, for any reason whatsoever. We have reasonable exceptions for the life and the irreversible impairment of major bodily function, which is a concession which we made, which we think is reasonable. As it stands, we think it's good, sound legislation. This, in fact, would gut it. I ask for a no vote.
Question is on the amendment. On that question, Representative Itkin.
Mr. Speaker, I'd just like to refer to Mr. Friend's own document. This is his memoranda of October 17, 1989, subject answers to questions relating to the Abortion Control Act of 1989, wherein he states on page 6 of said document that the 24-week period attacks, and that's my first, it attacks the trimester standards which Roe established. Secondly, it also attacks the health standards set up by Roe's companion bill, Doe v. Bolton. Contrary to what he said originally, that this bill, that the Supreme Court has not turned its back on Roe v. Wade. What Mr. Friend is proposing again is another tread on the Constitution in which he wishes to seek to pass an unconstitutional bill in order to have this bill presented to the courts, I guess with the hopes that the courts would further erode the constitutional freedoms and liberties available to the citizens of this great Commonwealth and the nation as a whole. Mr. Speaker, I feel that because of Mr. Friend's adamant stand to eradicate abortion, he is willing to put the health of the women of this Commonwealth in serious jeopardy. Perhaps not to commit them to death, but certainly to considerable health impairment, and I request that the House not give him that fiat, and I ask an affirmative vote on this amendment.
Question is on the amendment, and on that question, yeas and nays will now be taken.
Mr. Speaker.
Lady from Philadelphia, Representative Josephs, on the amendment.
I would like only to say, thank you, Mr. Speaker, I would like only to say that some significant number of abortions which are performed late in pregnancy are performed late because of the activities of the so-called pro-life group, which puts barriers before women who would much rather have early abortions. I think it's unfair. Mr. Speaker, may I have order, please?
Will the House be in order? Lady may continue.
Thank you, Mr. Speaker. I think it is dishonest intellectually. I think it is immoral. I think it is uncharitable to blame the women of this state for a condition that was caused by the people who are doing the complaining. Thank you, Mr. Speaker.
On the amendment from Bucks County, the yeas and nays will now be taken. On the amendment, members will proceed to vote. Have all the members present voted? Have all the members voted? Clerk will record the vote. On the question of agreeing to the amendment, the yeas are 47, the nays 152. The amendment fails. Question is, will the House agree to the bill? On that question, the lady from Montgomery County, Representative Haggerty, indicates that there is an amendment to be offered. Prior to the offering of this amendment and prior to the reading of the amendment by the amendment clerk, the chair is about to declare a 2-minute rule without objection. All the members of the House understand the 2-minute rule. Each member. I object. The chair will not impose with the intercession of an objection. The chair checked with both floor leaders and both with Mr. Friend and Ms. Ritter regarding the 2-minute rule, and they had no objection, and the chair felt comfortable in suggesting the 2-minute rule. If there are members of the House that object in substantial number or even in one number, we will not impose the rule from the Speaker's podium. Will the clerk read the amendment?
It's Amendment A 3339. Amend Section 4, Section 3211, page 7.
On the amendment, Representative Hagerty.
Thank you. Mr. Speaker, this amendment basically creates new language which would narrow the definition of after 24-week abortions from current law. Current law, as we've heard, is if the health of the mother is affected, a procedure to terminate the pregnancy can be done. Stephen Friend has suggested that that should only be able to be done when 2 doctors certify under penalty of a felony of the first degree that there would be substantial and irreversible impairment of a major bodily function. The language I am going to suggest is narrower than current law. Before I suggest the actual language of the amendment, I just want to focus this issue in the vocabulary it should be. These are delivery decisions. These are not abortion decisions. I share with you that I spoke this morning to my own obstetrician who said to me, we do not do, and the statistics you have heard essentially indicate there are not abortions going on in this Commonwealth after 24 weeks. There are real live decisions made about whether to deliver early because a woman is in dangerous jeopardy for her health. And so my language says that if she faces a substantial risk of death, serious physical injury, serious physical illness, or protracted loss or impairment of bodily function, that a procedure could be done to terminate the pregnancy. Keep in mind, these are women who want to have the baby, but that it is important that we allow doctors to make the determination of what is best both for her and the baby at that point, and that when we face a penalty of a first-degree felony over language that says irreversible, it is not going to protect the lives and health of our women. I conclude with the remarks of Thomas Jefferson. I have sworn upon the altar of God eternal hostility over every form of tyranny over the lives of men. This provision, which penalizes doctors and women to make real choices affecting the lives and health of real women, is tyranny over the lives of women, Mr. Friend.
Question is on the amendment. On that question, Representative Friend.
Thank you, Mr. Speaker. I rise to oppose the amendment. To repeat, what we said was after 24 weeks, there were 2 reasonable exceptions: to avert the death of the mother or for substantial and irreversible impairment of major bodily function. Now, what we have right now under our existing law is maternal life or health. Health permits you for any reason whatsoever at any stage to have an abortion. Once again, I'm not saying why women have abortions in late term, but I'm saying what Guttmacher Institute said, and that's Planned Parenthood's research arm. And they said for reasons for it's not even on the chart. Notwithstanding that, if you look at the language of the Hagerty Amendment, what you have, in effect, is a broad health exception. Death, fine, substantial risk of death. Serious physical injury. What is that? What serious physical injury? Serious physical illness. Once again, what is that? There could be any number of scenarios whatsoever. Remember what I said earlier. What we're trying to do is weigh life against health. Now, keep in mind, in cases where there's a health issue, when there's an induced childbirth, after the stage where the experts say there's a 50-50 chance for the baby to survive, that no longer is within the definition of abortion anyway. And that's frequently done where a baby is taken early to try to save the baby and also to assist the health of the mother. What this amendment does is take us back precisely where we are, which can afford no protection whatsoever to unborn children at any stage of pregnancy. I ask for a no vote. Thank you, Mr. Speaker.
Question is on the amendment. On that question, from Philadelphia, Representative Josephs.
Thank you, Mr. Speaker. When I last rose to speak, I blamed the anti-abortion movement for many of the late-term abortions we have, and I got such an angry reaction from some of the anti-abortion people around me. I know I must have been right. This time I rise
Question is on the amendment. The House will be in order. The Haggerty amendment is under discussion, and the representative will discuss the amendment.
This time I rise to present to you this hypothetical, which is certainly true in some instances, and to show you that voting against this amendment may actually cause more abortions also. And let me tell you why. A woman comes to her physician. She is in fragile health. She wants to have a baby. She is pregnant. The physician says to her, you live in a state, and if the anti-abortion people have their way, we will live in a country where it will be very difficult or impossible to get an abortion around the 22nd, 24th week of your pregnancy. Your health is very fragile. I advise you not to try to have this baby. I advise you to get your abortion right now. If you don't think that happens, you need to look at some of the testimony that we heard and hear some of the stories that we know. I believe that a vote on this amendment may cause some women, against this amendment, may cause some women who would otherwise have tried to have the baby to change their mind. Thank you, Mr. Speaker.
On the amendment, from Bucks County, Representative Heckler.
Thank you, Mr. Speaker. I asked the sponsor of the language which has now been placed in this bill what research had been done concerning the kinds of medical problems which would confront a woman late in pregnancy, which gave rise to this particular formulation of language which Representative Haggerty now seeks to change. It was particularly appropriate that I got no answer to that question because the original legislation that was introduced by that gentleman included no exception except when 3 doctors guaranteed that the woman would die unless she received an abortion. Now we have a new formulation in the bill which requires certain and irreparable harm. I don't know where that language came from. Perhaps, I hope at any rate, it's not from the same doctor who said that women can't conceive as a result of a rape. I would suggest that once again we're dealing with real life situations in which women's lives and their ability to reproduce in the future, their ability to survive a pregnancy are at stake, and I urge you to think carefully about this amendment and to vote for the Haggerty amendment.
On the amendment, from Philadelphia, Representative Weston.
Thank you, Mr. Speaker. Let's not forget that we're talking about the portion of Friends' amendment that deals with a baby that is 24 weeks into the term. What Representative Haggerty's amendment would do is broaden the ability of a woman to have an abortion after 24 weeks. I believe the current language in Representative Friend's amendment adequately protects women at that stage of the pregnancy, and more importantly, gives better protection to a baby who is 6 months along in the pregnancy. I urge no on this amendment.
Question is on the amendment, and on that question, from Dauphin County, Representative Piccola.
Thank you, Mr. Speaker. I would urge that the House adopt the Haggerty Amendment. I oppose the Itkin Amendment because it has always been my feeling that with respect to later term abortions, the definition of health was too broad. Yeah. And I congratulate Representative Friend for attempting to narrow it, but I think the point that Representative Haggerty is attempting to make is that it becomes difficult, if not impossible, in many cases. And we're not talking about a lot of abortions here. There are simply just not that many after 24 weeks in Pennsylvania. But what she is attempting to say is that the physician, if he can't certify with any definite reasonable ability that the illness will be permanent, he will not be able to certify that for health reasons. All Representative Haggerty is saying is that the illness or the injury would result in a protracted loss or impairment of bodily function. I'm not a physician, obviously, but it's my understanding that with respect to renal failure or diabetes, it is possible that in later term pregnancies, blindness or kidney failure is a possibility. But it may become difficult to certify, or for the physician to certify, that that will be permanent. And therefore, I think what Representative Haggerty is trying to do is arrive at a definition of health that is reasonable under the circumstances, is restrictive, and appropriately restrictive. And I would urge that her amendment be adopted.
From Cambria County, Representative Wozniak.
Thank you, Mr. Speaker. I was wondering if I could interrogate the maker of the Friend Amendment, Steve Friend.
He indicates he will stand for interrogation. You may proceed.
Thank you, Mr. Speaker. Would it be all right, Mr. Speaker, if I would run through a scenario and then the maker of the amendment could tell me if it would fit in his overall bill or not?
That might be appropriate.
Okay, it's very personal to me, and this will be very helpful in my decision-making process. Woman's in the late 7th month of her pregnancy, develops a high rate of toxemia, goes into the hospital one day. In the evening, the doctor makes a decision, the fetal monitor, the mother's all hooked up to make sure that gauging the blood temperature, blood pressure, and all that kind of stuff. The doctor comes in, makes a decision to induce labor. At this point, obviously, we are going to have a premature birth. Under your language, the Friend Amendment language, is this considered an abortion or a decision that the woman cannot, or the doctor won't be able to make this decision unless he has 2 other doctors in agreement, and that?
Thank you, Mr. Speaker. Number one, if it's prior to that period of time, let's say it's 6 months, and because of the toxemia, the physician believes that it could cause stroke, obviously that would be a threat to the life and also to the irreversible and substantial impairment of major bodily function. But secondly, when you're talking late 7th month, you're talking about 28 weeks. Most of the medical experts believe that at about 26 weeks, it's then 50-50 on survival. When it becomes 50-50 on survival, it's not an abortion anyway. It's a premature delivery. Because if you look at the definition of abortion, it's a procedure which A, ends the pregnancy, and B, is likely to cause the death of the unborn child. So in birth circumstances, the woman would be protected.
Thank you, Mr. Speaker. That was my concern. On the amendment, I would let everybody to decide on their own as to what direction they would like to go. But,
From Philadelphia, Chair recognizes Representative Linton on the amendment.
Thank you very much, Mr. Speaker. Mr. Speaker, in the current bill that we have before us with the Friends Amendment, Representative Friends makes reference to substantial and irreversible impairment of a major body function of the woman. and we have before us an amendment being proposed by Representative Hagerty. And I'd like to know under interrogation if Representative Hagerty would inform me of the type of illnesses that would occur that would allow the doctor to intervene in the pregnancy under her amendment.
The lady has consented to interrogation. May proceed with the answer.
Yes. Mr. Speaker, there are several illnesses, as I understand, that would allow intervention that would not necessarily, or at least comfortably, meet for the doctor Representative Friend's definition of irreversible, but would be very serious. One disease of that nature, I cannot pronounce the word, meganomania. It is a benign tumor in the head. It swells during pregnancy because it is fed by the hormones of pregnancy, causing severe impairment, but not necessarily permanent. There is a disease of the fatty liver of the pregnancy, which is a substantial liver degeneration, and if the baby is delivered, the patient generally gets better. Cystic fibrosis is another disease which is a congenital abnormal lung tissue. It creates stress on the lungs, and it can be necessary to deliver a baby early for that disease. Again, another disease which a doctor might not necessarily comfortably certify is irreversible, but is severely medically threatening and very serious to the woman. Lupus is another disease in which the immune system reacts against the body and kills cells in the blood-making system. There are also cancers, which, as I understand it, may not be life-threatening. Cervical cancer in early stages, breast cancer in early stages, but obviously, as we all know about cancer, as they progress, they become much more serious to the woman. The hormones fed by pregnancy cause that advancing cancer, but it's unclear whether or not they would meet Representative Friend's definition. And I think the point that has to be made is that the doctor must certify that it would meet that definition under penalty of a felony. So even though most of these diseases, two doctors must certify it, also I ask you to keep in mind that even under my amendment, you still need two doctors to certify that the disease would meet this very narrow definition that we are now proposing for health, for these terminations of pregnancy for the health of the mother in late pregnancy.
Thank you, Representative Hagerty. If I'm in order, Mr. Speaker, I'd like to make...
The gentleman is in order to make remarks on the amendment.
Mr. Speaker, I have two lovely daughters. And I'm very happy to have had the opportunity to be in the delivery room at the time of both of their births. But I also recall during the birth of my second child that there were some difficulties that occurred at that time on the fetal monitor. And I know at that time that I had to consult with the physician in terms of both the life of my daughter, but also what in fact that could potentially have to the health of my wife. That's a very, very difficult decision for anyone have to make. But it is a decision that I think should rest in the hands of that family and that physician who's there at that time. I don't think that we should try to impede medical practice. I don't think we should try to define some very narrow scope of medical practice that will inhibit the doctor from using all of the medical avenues that he has available. I think Representative Friend has gone too far. I think that in that difficult time, when that difficult decision has to be made, that serious risk of death, serious physical injury, serious physical illness, or protracted loss of impairment of bodily functions of the pregnant woman should be a factor. It should be a factor that should be allowed to be used in making that decision. I think that if the men of this House had to make that decision for their wife and were standing there at that time, that they too would find it a very, very difficult decision. But they would hope that the doctor, with all of his medical knowledge, will be allowed to use that to advise them on the right and correct choice to make. And I would hope that they would choose in favor of the woman. Thank you very much, Mr. Speaker.
From Wayne County, Representative Bermelin.
Thank you, Mr. Speaker. Just briefly to reiterate what Representative Friend said, I think you run the risk with this language here of opening up a loophole large enough to drive a Mack truck through. Serious physical illness and protracted loss or impairment of bodily function, again, sets health of the mother above life of the child. And I think that's wrong to do that. As difficult as these cases may be, we have to understand that we're not talking about just some simple medical procedure. We're talking about ending the life of a child and counterbalancing that with the health of the mother. And I think it's very important that you must, in this case, as in these other cases we've discussed, you must opt for life. You and I all know of cases where people have been told that, oh, if you carry this child to term, you're going to die, or you're never going to be able to walk again, and all these other scenarios. And these people are walking our streets today and having happy and fruitful and productive lives. And I think it's wrong to say we're going to kill someone, we're going to eliminate a life, simply because someone else may have a health problem. And I think that's wrong to do that, and I would ask for a no vote on the Hagerty Amendment.
From Lehigh County, the chair recognizes Representative Ritter.
Thank you, Mr. Speaker. I wonder if the gentleman, Mr. Friend, would stand for a moment of interrogation.
He indicates that he will. You may proceed.
I have a couple of questions. First of all, we've heard, and I've heard this now several times, where you've referred to someone from Planned Parenthood who has talked about abortions that are done after viability and that only 2% or some such number are done for purposes of life and health. Can you fill us in on where this information came from?
Yeah, that was a survey done not by a person, by the Guttmacher Institute, which, as you know, is the research arm of Planned Parenthood. So they are not my conclusions. They are the conclusions reached by the Guttmacher Institute, an arm of Planned Parenthood. This, in fact, is in an article, Why Do Women Have Abortions? What's this taken from? That's taken from the... written by Ada Torres and Jacqueline Doric Forrest, published by the Guttmacher Institute. And in fact, it has a number of polls as to why women have abortions at early stages and also at later stages. And in fact, their chart, not mine, indicates that with respect to late-term abortions, health is not even on their chart. So, Mr. Speaker, if you have a problem with that information, your problem is not with me, it's with the Guttmacher Institute.
The problem is not with the information, it's with your interpretation of the information, because no one from Planned Parenthood or any other organization has ever seen this language, and we feel that it is being misrepresented as coming from Planned Parenthood.
I find it hard to, if that's a question, I find it hard to believe that Planned Parenthood has not seen the information published by their research arm, its research arm.
Does the survey that you're talking about refer to a particular time period? Is it the 24 weeks that you've set it at? Does it refer to viability, or is it all abortions that are done for those reasons?
With respect to late term, they break it down. It's after 16 weeks.
After 16 weeks?
After 16 weeks. Not 24, 16.
All right, so again, that we're not talking about viability at that point.
No, as a matter of fact, we're talking about even before. When you're talking about health in later stages, this goes to 16 weeks, and it says 16 weeks and thereafter, anytime thereafter. Health isn't even on the chart.
All right. Thank you, Mr. Speaker. In terms of this information, what you have to keep in mind is the statistics that I gave you from the Department of Health, which are on your desk, which show you the very, very small number of abortions that are done after viability. So if you're including abortions that are done from 16 weeks on, then a 2% number may be likely, because the number of abortions performed after the viability point is so very small that the total effect on the percentages is also going to be very small. So again, we've got numbers which are manipulated to make a situation appear which is really not the case. I want to support this amendment, Mr. Speaker, because, if I may speak on it.
Ladies in order.
Thank you, Mr. Speaker. I rise to support this amendment. This amendment has been very carefully drafted by the lady, Mrs. Haggerty, to address the specific concerns that we've talked about, specific conditions, including toxemia and all the other lists that you have. I personally had the situation where my mother had toxemia when I was born, and I was an early delivery. Now, whether or not you're talking about an abortion or an early delivery, as defined in this bill, you're putting a burden on the physicians who have to work with this language. And if at the point of 24 weeks they perform an early delivery, either an induced delivery or a C-section, and they can't save the fetus because it's not viable at that point, they may be liable for a first-degree felony which could put them in jail for up to 20 years, fine them up to $25,000, and require them to lose their license. Now, if you think that any physician is going to make a judgment that could cause him those kind of penalties, and you think he's not going to just walk away from that case rather than find himself in that situation, then you're crazy. We're talking about medical malpractice rates in this state that are incredibly high, and this is certainly going to add to that. So if you have any concern for the physicians and their malpractice rates, that's a reason enough to substitute the Haggerty language, which puts the discretion back in the physician's hands where it belongs. We are not talking about anything but serious situations, serious health problems, conditions which may be substantial but may not be irreversible. And that's the problem with the language in the Friend Amendment. That's what this amendment will address. Situations which will have substantial impairment but which are not irreversible, such as a stroke and such as cases of toxemia. So I would strongly suggest that the members support the Haggerty Amendment. Thank you.
From Delaware County, Representative Friend.
Very, very briefly, Mr. Speaker, to repeat, if this amendment is adopted, we go back to where we are now, maternal life or health. Very, very general, which when you look at the language, and I don't know what the language means, serious physical illness, what's protracted loss or impairment of bodily function of the pregnant woman, you are giving what we have now a broad-based health exception, which defined by the courts means any time for any reason. We very carefully balanced this after 24 weeks. When it's life of the mother against life of the baby, it's life of the mother. When it's serious and irreversible impairment of major bodily function of the mother against the life of the baby, it comes down on the side of the mother. When, however, it is health in its broadest sense of the mother against the life of the unborn child, common sense seems to dictate that the scales must be tilted in favor of life. I sincerely hope that we reject the Haggerty Amendment. Thank you.
From York County, Representative Foster on the amendment.
Thank you, Mr. Speaker. I rise to oppose the amendment, and the statements made just a moment ago by the lady from Lehigh prompted me to take the microphone against my better judgment with my physical condition today. However, I think if you're making a judgment between an early delivery and a late abortion, the language contained in the bill is much more likely to cause physicians to opt for an early delivery. And I don't want to see that language disturbed. I sincerely advocate that you vote against the amendment.
On the amendment, yeas and nays will now be taken. Members will proceed to vote. Have all the members present voted? Have all the members voted? The clerk will record the vote. On the question of agreeing to the amendment, the yeas are 70, the nays 131. The amendment fails. Is there another amendment to be offered by Representative Hagerty? Is there another amendment, Representative? The amendment will be sent to the clerk. The clerk will read the amendment. Prior to reading the Hagerty amendment being offered at this time, the Chair would like to announce for Representative Andrew Karn from Philadelphia that he has unfortunately lost about 10 keys, which are very important to him. He misplaced them somewhere in the hall of the House. If any member sees on his desk or near his desk a set of 10 keys, they probably belong to Andrew Karn if they are foreign to the member or the place they may be. Chair would like all the members of the House to know that today is the 47th wedding anniversary of Representative William Rieger and spouse. The clerk is about to read the Hagerty amendment.
This is Amendment A 3402, amend Section 4, Section 3211, page 7.
Will the House be in order? The gentleman previously objecting to the imposition of the 2-minute rule has withdrawn that objection. The Speaker would like to impose the 2-minute rule if there are no other objections to the 2-minute rule. Members will be able to speak twice on every amendment before us, but each time they will be limited to 2 minutes. Without objection, the Chair would indicate.
Mr. Speaker.
Gentlemen.
Point of parliamentary inquiry.
Are there objections? Are there objections to the imposition of the 2-minute rule?
Mr. Speaker, point of parliamentary inquiry in regard to the possible raising of such an objection.
State the point of parliamentary inquiry.
Mr. Speaker, if the 2-minute rule is invoked and a speaker has a desire to finish a train of thought or finish something that he thinks is important for the House, that for all intent and purposes has not been raised yet in today's debate, and that speaker would so notify the chair, would there be the opportunity for that individual to continue that particular issue or subject matter and not be cut off and deprived the right of so advising the chamber?
2-minute rule indicates that members have 2 minutes to speak, and I don't know how to change the 2-minute rule on the spur of the moment. Without being unfair to someone, if you object to the 2-minute rule, I will not impose the same. Is there an objection to the 2-minute rule?
I have a parliamentary inquiry also, Mr. Speaker.
State your point of parliamentary inquiry, Ms. Joseph.
If the 2-minute rule is imposed, is it imposed for the end of the debate on this amendment and bill, or is there any way to lift it?
For the duration of the amendments.
The imposition of the 2-minute rule by the Speaker is an imposition of a rule which contravenes the rules of this House. It can only be imposed when all members of the House are in agreement. Anytime a member objects, he can incur the wrath of the House, but he can dispose of the rule.
Thank you, Mr. Speaker.
Mr. Speaker.
Is there an objection to the 2-minute rule?
Parliamentary inquiry, Mr. Speaker.
State your point of parliamentary. I'm not going to spend a half an hour here discussing whether or not we should go into a 2-minute rule. Mr. Davies, what's the point of parliamentary inquiry?
In your ruling, sir, does that include the matter of interrogating the individual?
Certainly does. Members entitled to the floor twice, 2 minutes each time. Without objection, the chair will institute a 2-minute rule. Each member will speak 2 minutes on the subject matter before the House. He will speak no more than twice. Chair recognizes on the amendment. Are members in receipt of the Haggerty Amendment A3402?
I don't know why she's getting it up.
It's not in the packet. In the packet?
Start now.
It is not in order to consider an amendment that is not on the member's desk. We will have to pass over that amendment at this time.
Mr. Speaker, it is in the packet that was distributed by leadership. It is the last one, I believe, in that packet, which is now on the members' desks.
Is there anyone that does not have a copy of the amendment? Anyone wishing a copy of the amendment, indicate to the pages. The amendment appears to be in the packet.
Mr. Speaker, I correct that. It is the third from the last amendment in the packet that was distributed.
Question is on the amendment, Amendment 3402. And on that amendment, the author of the amendment, Representative Haggerty.
Thank you. Mr. Speaker, it seemed to me that many of the members on the last vote were concerned with the language of my prior amendment, which they thought created too big a possible loophole because of the words serious physical illness or impairment of bodily function. This amendment, I believe, corrects those concerns. It is very narrowly drawn, and what it does is it takes Representative Friend's language, in which his language says that in order to terminate a pregnancy after 24 weeks, there must be substantial and irreversible impairment of a major bodily function. This changes the and to or. The reason I suggest the or is because of the nature of the certainty of the judgment which irreversible impairment calls upon the physician to make. It seems to me that this corrects all of those concerns because this amendment means that it must be substantial impairment or irreversible impairment of a major bodily function of the woman. I don't think that anyone can suggest that this standard can be subject to abuse or too broad. I also, and I wanted to say it in the last debate and didn't get a chance, want to call your attention to something very important. Representative Friend's amendment provides, and I don't change the fact, that the physician must attempt to do, if he is doing a termination of the pregnancy, hopefully for purposes of delivering the baby, that it must be done in the manner most likely to result in the live birth. Again, unless it meets this very strict definition of the woman's health. The reason this is a concern is because abortion and delivery, while members might like to believe are different, when we're talking about late pregnancy, we are talking about terminations. We want them to be done to have live babies. My 2 minutes.
The question is on the amendment. On that question, does Representative Haggerty wish to be recognized for the second time?
No, I'll conclude my remarks.
Representative Friend from Delaware County on the amendment.
Once again, Mr. Speaker, I rise to oppose this amendment. As I indicated before, we were very careful on how we drafted this exception. Substantial and irreversible. When you make it or, what in fact you do is almost precisely the thing that you did in the previous amendment, which you overwhelmingly defeated. For example, if in fact the pregnancy might cause someone not to be able to walk for several days, that's substantial. It's not irreversible. When you make it or instead of and, what you in fact do is take it back to the broad-based health exception. And again, and I hate to keep saying this, we tried to weigh life against life, it's the life of the mother. substantial and irreversible impairment of bodily function of the mother against life of the unborn baby, the scales come down on the side of the mother. But when in fact you have health, which is not both substantial and irreversible impairment of major bodily function against the life of the unborn baby, the scales have to be tipped in favor of the baby. I would sincerely ask for a negative vote on this amendment. Thank you.
Question is on the amendment. On that question, the yeas and nays will now be taken. Members will proceed to vote. Have all the members voted? Have all the members present voted? Clerk will record the vote. On the question of agreeing to the amendment, the yeas are 74, the nays 126. The amendment fails. Will the House agree to the bill as now amended? And on that question, Representative Heckler indicates there is an amendment to be offered. Clerk will read the Heckler amendment.
Amendment A 3341, amend Section 4, Section 3211.
The question is on the Heckler amendment 3341. And on that question, Representative Heckler is recognized.
Thank you, Mr. Speaker. Mr. Speaker, this is a real-world amendment. As we have already heard, relatively few post-24-week abortions occur. Now, under the Roe v. Wade standards which have prevailed in this state, less than 2% in 1988 of all abortions occurred after that time. I would suggest to you that many such abortions that occur at that late date arise because physicians have diagnosed a fatal anomaly in the fetus. My amendment would add, as an exception to the absolute prohibition which Representative Friend's language imposes, an exception where a fatal anomaly has been diagnosed in the fetus. We're not, in this amendment, talking about freckles. We're not talking about cleft palate. We're not even talking about Down syndrome. We're talking about a situation in which a doctor, hemmed in by all of the concerns and safeguards and felony provisions that are included in this piece of legislation, says, Mr. and Mrs. Jones, your baby is dead. Your baby is going to die, certainly, because of some recognized medical condition. Ladies and gentlemen, on the floor in this debate, so far, we have frequently heard arguments against restrictions, rather in favor of restrictions on abortion, begun by the words, I believe. We all respect those beliefs, individually held. But we simply were not sent here to substitute our beliefs for the agonized judgment of a man and a woman who have been told by a doctor that the baby they want very much will surely die whenever it is delivered. Thank you.
The question is on the amendment. On that question, from Lehigh County, Representative McHale.
Thank you, Mr. Speaker. Would the gentleman, Mr. Heckler, stand for interrogation?
The gentleman indicates he will.
Mr. Heckler, the concern that I have is with regard to the timing of the doctor's decision. And I'm not sure that I understand the language as it's presented in your amendment. You indicate that a post-24-week abortion can occur where the doctor determines that there is a fatal anomaly present in the fetus. My question is, fatal when? If the doctor, for instance, determines that the fetus, which is 25 weeks old, will die within 2 to 3 weeks, would your amendment cover that situation?
Will die, I'm sorry, within 2 to 3 weeks of the time when the diagnosis is given?
Yes.
It would certainly cover that situation. My amendment is intended to cover any situation in which the doctor can ascertain with certainty, and I might point out that under the underlying bill, it's two doctors, that the fetus will die. That could be, as in the case of an ancephalic child, at the time of birth or shortly thereafter, or during the gestational period.
That's my concern, Mr. Speaker. There is no limit as spelled out in your amendment. You say shortly after birth. There is no limit to when after birth, whether we're talking about a few minutes, a few days, a few years. And I think that that lack of precision raises some very troubling questions. If you could address that issue, I'd appreciate it.
Is that a question?
Yes.
Well,
you indicated shortly there that your amendment is intended to cover fatalities which the doctor diagnoses might occur shortly after birth. And my concern is that there is no limitation on what you mean by shortly after. A few minutes, a few days, a few months, a few years.
My amendment is intended to comprehend any situation in which the doctor can say with certainty that the condition, medical condition he is diagnosed will certainly result in death.
I thank the Speaker.
The question is on the amendment. And on that question, from York County, Representative Foster is recognized.
Mr. Speaker, my only regret is that the beautiful young lady who shared this story with me could not be here to relate it personally. But when she was conceived, her mother contracted German measles, and the despairing parents were told by the doctor that absolutely they should terminate that pregnancy, absolutely end it, because the child is going to be hopelessly deformed. And thank God the parents had a little more faith and trust, and the child was born, and today she's a beautiful young lady. I would ask for a negative vote on the amendment.
Question is on the amendment. On that question, yeas and nays will now be taken. Members will proceed to vote.
Mr. Speaker.
Sorry. Mr. Gentleman, Mr. Heckler. On the amendment, Representative Heckler.
Thank you, Mr. Speaker. The first woman to be confronted in Missouri with the restrictions which were upheld by the court, which leads, so we hear, to all of this, were forced to seek an abortion elsewhere because the fetus that woman was carrying lacked a number of its vital organs. That woman almost died before that abortion could occur. Her husband said, "I'm not pro-choice and I'm not pro-life," but nobody who wrote this law was thinking about us. I ask you, ladies and gentlemen, to think about whether we were sent here to tell a woman who has been assured, not that the baby may be seriously deformed or terribly deformed, but that the baby has an identifiable condition, ancephalic, occurs 1 in every 1,000 to 2,000 pregnancies. There is no brain. Unlike the advocates who bombard us with mail, I didn't send around pictures that I've obtained of an ancephalic monster, as it is called. To have your wife, your daughter, you, for those of you who are women, told that that's what you're carrying, and because the Pennsylvania legislature has in its wisdom decided that it is better as a matter of policy that you carry that ancephalic monster or that Potter's syndrome infant that has no lungs or kidney to full term so that you can deliver it to die. If that's what you think we're here for, then vote against this amendment by all means. I urge you, however, to recognize that those kinds of decisions at least belong within the purview of the individuals who are faced with this terrible situation.
Question is on the amendment. On that question, from Berks County, Representative Lay.
Thank you, Mr. Speaker. The gentleman from Bucks County made the remark that this is the real world, and that is true. This is the real world. There's a number of amendments that have been offered here today, and more will be offered, that deal with specific hard case issues. And let me remind you that if we make exceptions for every hard case single issue that comes along, we will end up with no law at all. And I think the Friend Bill addresses these situations quite amply, and I would respectfully ask you to reject the Heckler Amendment, and let's get on with the business. Thank you, Mr. Speaker.
From York County, Representative Snyder.
Speaker, may I interrogate the sponsor of the amendment?
Gentleman, Mr. Heckler indicates he will consent to interrogation. You may proceed.
Mr. Heckler, what do you mean by the term shortly after birth? Or the phrase shortly after birth?
That was part of an answer I gave previously. I don't believe this amendment does fix a specific time. I think the gentleman is quite right about this. I think this amendment deals with any situation which is diagnosed by two physicians as being fatal. That could be prior to when birth would normally occur or thereafter.
For an unspecified period of time thereafter?
Yes.
That concludes my interrogation. Thank you.
Question is on the amendment. On that question from Montgomery County, Representative Hagerty.
Thank you, Mr. Speaker. Mr. Speaker, if I only speak once and I go over 2 minutes, may I use my other 2 minutes at the same time?
The Speaker will allow the second 2 minutes to be taken at that time. I will indicate when the first 2 minutes is up, and if you want to continue to speak, you can.
The reason I asked that question is I want to share a story on my personal situation, which I shared with my caucus yesterday for the first time publicly, and I felt it was important, although it's difficult to do so, because my heart breaks for the people who may encounter this situation. As many members of this House know, I was pregnant, I think it's now 7 years ago, and gave birth to a stillborn baby. That baby died 2 weeks before delivery. The baby died because it had severe congenital abnormalities. That baby, God made that decision. I did not know that the baby would not live, and so I was not faced with the situation in this amendment. I want to share it with you, though, because I had the experience of carrying a baby without a heartbeat. And I want to suggest to you that if a doctor tells a woman, and there are certain situations, they are few, but they are certain, in which a doctor can assure a woman that a baby will not be born, that baby will not be able to live, I think that to make that woman carry a baby, knowing that that heart is going to stop any day, knowing that she must endure the remainder of that pregnancy with a baby that she knows for certain is going to die, is a cruel and hard and wrong thing to do to women. And so I think it's important that we support this amendment. Thank you.
From Philadelphia, Representative Josephs on the amendment.
I want to thank Representative Hagerty for sharing that in public. I had not known it before, and that makes me feel very sad. And I hope that those of you who vote against this amendment understand that you are hurting your own colleagues here.
Question is on the amendment. Representative Friend from Delaware County.
Thank you, Mr. Speaker. I rise to oppose this amendment. I said at the very outset that there were many wrenching cases, and I was aware of the situations with Representative Hagerty when it happened. And I was very sorry, as I advised her then. But that's not the issue with this amendment. This amendment says fetal anomalies have been diagnosed. Number one, there's no definition of a fetal anomaly. What's it mean? I don't know. Mr. Heckler, in response to interrogation, has said there's no time limit. We're not just talking about a baby who tests indicate will die before he or she is born, but who will die any time thereafter. 2 years, 3 years, 4 years. As a matter of fact, Huntington's disease, which can be diagnosed prenatal, attacks generally when you're 40 years of age or older. Where do we draw the line? I will take Mr. Heckler at his word. He said when any indication has been developed that an unborn child has a diagnosis which means that he or she will die. Every one of us who have ever been conceived have that diagnosis. It's called humanity. And unfortunately, we know that sometime following our birth, we are all going to die. This amendment, with no definition and no limitation, permits you to have an abortion for any reason whatsoever, because we're all going to die. It doesn't define it. It doesn't extend the time period. It's an extremely dangerous amendment, and I sincerely hope that we reject it. Thank you, Mr. Speaker.
The question is on the amendment, and on that question, yeas and nays will now be taken. Members will proceed to vote. Have all members present voted? Have all the members present voted? Clerk will record the vote. On the question of agreeing to the amendment, the yeas are 73, the nays 126. The amendment fails. Chair recognizes Representative Ritter, who indicates there is an amendment to be offered. Will the clerk read the Ritter amendment?
It's Amendment A 3409, amend Section 4, Section 3211, page 8.
Question is on Ritter Amendment A 3409. The chair recognizes the amendment's author from Lehigh County, Representative Ritter.
Thank you, Mr. Speaker. This amendment deals with the section of abortions after viability. And again, remembering that under this section, a physician is required to use the method of abortion which would best provide an opportunity for the unborn child to survive, which means we are talking about induced delivery or C-section. We're not talking about the difference between saline and D&E abortions and early delivery. We're talking about the difference between an induced delivery and a C-section. What this amendment will do is provide the physicians the opportunity to use their best judgment as they have in the past, and we're not going to interfere with that judgment by requiring that a significantly greater risk must exist before the woman's health can even be considered. This is saying where it would not pose an additional risk to the life or health of the pregnant woman, then the physician would decide between the induced delivery or the C-section. Again, we're talking about those two methods of abortion, one or the other. And we're saying that it should be the physician's judgment based on the wishes of the family at that point as to whether an induced delivery should be done or whether a C-section should be performed. Remember that we're talking about major surgery when you're talking about a cesarean section. Also remember that we're talking about 24 weeks and not necessarily viability. So what you may be doing is requiring that with using the language significantly greater risk, you may require that the woman's health be put in at some risk to provide the best method of delivery for a fetus which is not viable and which cannot survive. So again, we're allowing the physicians to use the judgment in balancing, as they have said, there are two patients at that. Once they get to viability, all physicians consider that they have two patients. And we think that they should have that opportunity, and I would ask for a yes vote.
The question is on the amendment. On that question, from Delaware County, Representative Friend.
Thank you, Mr. Speaker. Once again, when we drafted the amendment, which we've already overwhelmingly passed, we were very careful. We said after 24 weeks, no abortion except to avert the death of the mother or substantial and irreversible impairment of major bodily function. Then we went on to say, except in a medical emergency, the physician has to terminate the pregnancy in a manner which provides the best opportunity for the unborn baby to survive, unless the physician determines in his or her good faith medical judgment that termination of the pregnancy in that matter poses a significantly greater risk either of the death of the mother or of the substantial and irreversible impairment of major bodily function. So once again, we're getting down to the same issue that we fought 5 or 6 times in the fetal already, the balancing of broad-based health against the life of the unborn child. For the reasons we set forth before, for the reasons which you've defeated these amendments before, I urge the defeat of the Ritter Amendment. Thank you, Mr. Speaker.
On the amendment, yeas and nays will now be taken. Members will proceed to vote. Have all the members present voted? Have all the members present voted? Clerk will record the vote. On the question of agreeing to the amendment, the yeas are 58, the nays 142. The amendment fails. The question is, will the House agree to the bill? And on that question from Philadelphia, Representative Josephs indicates there is an additional amendment. Clerk will read the Joseph amendment.
It's Amendment A 3367, amend Section 3, page 4, line 55.
Thank you, Mr. Speaker. I really do ask people for their attention on this amendment. It is a little bit different than some of the ones that have been before, because it talks about contraception and contraceptive devices. It is an affirmation on your part, if you vote for it, that you do not intend to take out of the hands of Pennsylvania women generally medically acceptable contraceptive devices and methods. And I do it for several reasons. I would go immediately to the first one, which concerns some remarks that were made by Mr. Friend when we were on television together, in which he said, if Roe v. Wade is overturned and we can outlaw abortion, we will leave it up to the Pennsylvania Drug, Device, and Cosmetic Board, they are the experts, to decide which pills and devices are abortifacients, and we will outlaw them. Let me tell you, ladies and gentlemen, that as I understand it, the pill, the contraceptive pill, can be used as an abortifacient. If you vote against my amendment, you've got to take it out of the hands of your constituents. And this is how it is used. And the physician will tell his patient or her patient, if you miss taking the pill Monday and Tuesday, you might be in a very, very early stage after conception. Take 2 pills on Wednesday and 2 pills on Thursday, and there's a very good chance that you will not get pregnant. I want everybody here to understand that. Thank you, Mr. Speaker.
Question is on the amendment offered by Representative Josephs. Representative Friend?
Thanks, Mr. Speaker. I really don't know what the amendment means. We don't define contraception, but let me make it clear. The Abortion Act has nothing to do with contraception. We make that clear in the definition. So despite the fact that it's poorly drafted, it's certainly not, in my opinion, going to do any harm. I'm certainly not going to oppose this amendment. We're good for our word, Mr. Speaker. Thank you.
Question is on the amendment. On that question, yeas and nays will now be taken. Members will proceed to vote. Have all the members present voted? Have all the members voted? Clerk will record the vote. On the question of agreeing to the amendment, the yeas are 188, the nays 10. The amendment has been adopted. Question is, will the House agree to the bill as now amended? And on that question, from Allegheny County, Representative Murphy is recognized, indicating there is an additional amendment. Clerk will read the Murphy Amendment A3432.
It's Amendment A3432. Amend Section 3, page 4, lines 55 through 59.
On the question of adopting this amendment, the chair recognizes its author from Allegheny County, Representative Murphy.
Thank you, Mr. Speaker. This amendment strikes the spousal notification section of the bill. Section 3209. Mr. Speaker, while I'd like to think in each marriage that a husband and wife would look to joy with a pregnancy, I think we can all think of many circumstances where a woman might not feel either safe or comfortable notifying her husband of that pregnancy during separation. And in those cases, I think it's inappropriate for the Commonwealth to try to put in place a few exceptions and then to require that woman to sign a statement that she has notified her husband. I believe that there is responsible public policy that we can enact to regulate abortions. I do not believe that the spousal notification section of this law in any way is either reasonable or necessary. I think it goes beyond what is good government regulation to suggest that we can enact and regulate the communication between a husband and wife. This is government gone amok, and I would urge your support of my amendment to strike this section. Thank you, Mr. Speaker.
From Delaware County, the chair recognizes Representative Friend.
Mr. Speaker, so everybody knows what this amendment does, it completely takes out the spousal notification section. Obviously, I oppose it. A husband at least has the right to be notified that he and his wife have created an unborn baby, their child, and that unborn baby is going to be killed. We put 4 reasonable exceptions in there. And that's where the husband's not the father of the baby. It's where the husband can't be located after due diligence, where the pregnancy is a result of spousal rape, and where giving out this information would place the woman in danger of physical harm. But let me tell you something, married or not, our law is very clear that the father of that unborn baby not only has a right, but an obligation for the financial support of that baby, and that's as it well should be, even if he's offered to pay for an abortion. Well, you can't have it both ways, Mr. Speaker. At least the husband, within the marital context, has the right to be notified that his child and his wife's child, unborn child, exist and is going to be killed. This is one of the best sections of the bill. This amendment would take it out. I hope that we overwhelmingly defeat this amendment. Thank you, Mr. Speaker.
From Dauphin County, Representative Picola on the amendment.
Thank you, Mr. Speaker. I would urge that the House support the Murphy Amendment. This provision of the bill is a very, very bad precedent, in my opinion. The General Assembly, over the years, since this Commonwealth was founded, has, as a matter of public policy, encouraged and protected the institution of marriage, but very rarely, in very rare instances, have we governed the operation and the conduct of parties within the marriage. We have set forth the threshold requirements for individuals to enter into a marriage, and we make sure that they meet those thresholds. They are health requirements, and thereafter we give them a license to get married and to enter into the marriage relationship. At the other end of the spectrum, Mr. Speaker, we set forth the rights of the individual parties, the husband and the wife, when a marriage is ending or when it is in trouble. Custody, alimony, divorce rights, child support, division of property. These are a few of the areas that we have governed the conduct and the rights of parties. But nowhere in the law, Mr. Speaker, and this will be the first time, and I don't believe we should do it now, where we tell a husband and a wife what they must say to each other during a marriage. In fact, just the opposite. We have endorsed, with respect to property rights, the common law principle that a husband and wife own property in the entireties. That is, they are an inseparable institution. We have also made spouses incompetent to testify against each other in civil and in most criminal matters, the exception being when there is spousal abuse involved. And these communications are privileged. Quite frankly, Mr. Speaker, and I'm speaking as a conservative who believes that government simply sticks its nose into too many places where it does not belong, this provision of this amendment of Mr. Friend's is wrong. May I use my additional 2 minutes, Mr. Speaker? If you're going to ask me whether I think a husband and a wife should communicate in a marriage, I say yes. If you ask me whether a wife and a husband should communicate about the use of birth control or contraception, I would say yes. If you ask me whether a wife should tell a husband that she is pregnant, I say yes. And if you ask me whether a wife should tell her husband that she is thinking about or is going to obtain an abortion, I again would say yes. But if you ask me if the state of Pennsylvania, this General Assembly, should mandate under punishment of law that a wife has to do or say any of these things, then I say no. We are setting up a statutory mandate of communication within a marriage. We are taking the first step which will lead to the dissolution of that marriage. It has been my experience, and I'm sure it has been the experience of everyone else in this chamber who is married, that marriage is based on love, trust, communication, and a whole host of other feelings and emotions which simply cannot and should not be regulated by government. This is big government at its worst, Big Brother at its worst, and I urge that we adopt the Murphy Amendment.
From Philadelphia, the chair recognizes Representative Josephs.
Thank you, Mr. Speaker, for the compliment, the promotion. May I have order? Sir?
Will the House please be in order?
Ladies and gentlemen of the House, I really think you need to pay attention to this debate. What Mr. Piccola has said so ably is that, Mr. Speaker, I'm afraid when I call you to ask for order, I'm using up my 2 minutes, and I don't know really what to do in this situation.
I will let you speak 2 minutes on the question.
But I would like to speak in such a way that people who want to listen can hear. There are two sides of speaking.
You are now using up your 2 minutes.
Thank you, Mr. Speaker. I hope that everybody who votes against the Murphy Amendment understands that you are voting against mature, married women who are paying for their procedure themselves. And I would like to see you explain that to the mature, married women who are paying for the procedure themselves, who are your constituents. I thank you, Mr. Speaker.
Chair recognizes on the question from Allegheny County, Representative Preston.
Thank you, Mr. Speaker. Will Mr. Friend answer a short question for me, please?
Will he answer it short, or will the question be short?
Yeah, I understand the question.
Gentleman, Mr. Friend, will you consent to interrogation? The gentleman indicates that he will.
Mr. Friend, currently the bill, am I right that this only deals with married people? It does not deal with a single woman having to notify the father, or not?
It's only spousal notice.
Okay, thank you. Mr. Speaker, may I speak on the amendment?
Gentleman is in order.
I think that this is the epitome of elitism. What we are denoting here is that any married woman has totally become a third-class citizen. What we are saying to anyone who is married, and it's just setting a precedent, a very frightening precedent that could cause us to possibly be the laughingstock across this country. I think that this is an insult not only to my wife, but to your wives, because it only deals with married people too. And if Mr. Friend really cared, he would be simply stating that every husband ought to notify his wife if his girlfriend is having a pregnancy or any other point. It's a second-class statement, and it's not fair and it's not appropriate. I am not going to be laughed at, and I really think we ought to support the Murphy Amendment. This is really, truly an embarrassment, and it really brings us back to the 1600s, whereby women didn't even have the right to vote. Now they don't even have a right to speak unless their man tells them so. Let's support the Murphy Amendment.
On the amendment from Philadelphia, Representative Richardson is recognized.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to interrogate Mr. Friend.
You are in order, and he has consented. You may proceed.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to know whether or not you've ever been impregnated.
That I've ever been pregnant?
Have you ever been impregnated?
Not to my knowledge, Mr. Speaker.
Do you know anything about a person that has been impregnated?
Run that one by me again. I'm sorry, Mr. Speaker, I didn't hear you.
Do you know anything about a person who has been impregnated?
Yeah, I have a wife who has blessed herself and me with 6 children.
And each time that she had conceiving of children, did you sign any papers to allow her to have the babies?
No, Mr. Speaker.
Mr. Speaker, I'd like to be in order to speak on the bill.
Gentleman is in order.
Mr. Speaker, I rise to support the Murphy Amendment. I do so, and I'd like to say that I think that not only are we barking on the wrong tree, but I think that anybody that places themselves in the position here this afternoon of thinking that they can just run roughshod over their wives by saying that the wife has to now get consent from the husband is crazy. I think that it is very clear to me that we are now embarking on one of the most dangerous areas that I've ever seen witnessed on the floor of this House. I don't know where Friend gets the attitude that he feels as though he can superimpose his will on everybody else on the floor of this House and then all of a sudden act like he is the epitome of the epitome. I think that people are very clear about the fact that women in this country should have a right to choose over her own body, and that when it comes to making a decision about having that baby, a husband does not have any right to superimpose his will by signing any paper or agreeing if in fact that woman makes that decision. And today I think it's no different. I think that what we have done is we've stretched ourselves beyond the call of duty. We're being male chauvinist pigs in a situation where we have no right to superimpose our will as a husband or male on another individual. If your wife, I'd like to know whether or not I can use my other 2 minutes, Mr. Speaker. Thank you very much. If your wife is in a situation where you've been separated from your husband for X number of years and you don't even see your husband and get impregnated, how do you contact him to in fact get his consent? If Mr. Friend, who's a former FBI agent, in fact recognizes that there were times when they had to go arrest people and they try to find a particular spouse and the wife did not know where she was, they didn't lock up the wife. So the same parable exists within respect to a person who is in fact impregnated. We cannot superimpose that will on other individuals in this Commonwealth, and I ask for an affirmative vote on the Murphy Amendment.
Question is on the amendment, and on that question, the chair recognizes from York County Representative Foster, but before the gentleman begins his debate, the chair would like to ask Representative Wambach to preside temporarily for the speaker.
The chair recognizes the gentleman from York, Representative Foster.
Thank you, Mr. Speaker. I'm frankly baffled by that anyone would oppose this section of the bill and seek to remove it. We're talking about notification, not consent, but notification to a spouse. Not a live-in, not a paramour, not a one-night stand, a spouse. Isn't that the least that you can do for a lawful spouse, is to require notification that that spouse's child is about to die? Let's consider just a moment a rough-hewn old husband who has said repeatedly to his wife, I don't want any children, we don't want to be bothered with children, and the wife suddenly finds herself pregnant, and she takes her husband at his word and thinks, oh my, all these years he said he didn't want children, well, I guess I better go get an abortion and never tell him. How many times that husband would worship that little child when it's born? Mr. Speaker, we must defeat this amendment.
Chair thanks the gentleman. The chair recognizes the gentleman from Wayne, Representative Bermelin.
Thank you, Mr. Speaker. The net effect of what I'm hearing people say who support the Murphy Amendment is that the husbands in Pennsylvania ought to be reduced to stud service. We don't want to have anything to do with the carrying of a child. We just want to get the women pregnant and they can do whatever they want from that point on. Well, that's not what marriage is all about. That's not what responsibility is all about. That's not what child rearing is all about. And I think that child that is in that wife's womb is a product of those two people, and he has a right to know what's going on as much as he has a responsibility to support it, and to say that he has no right and no concerns is ludicrous. And I think you're emasculating the men of Pennsylvania when you do so. The Murphy Amendment ought to be defeated soundly.
The chair thanks the gentleman. The chair recognizes on the amendment the gentleman from Allegheny County, Representative Cowell.
Mr. Speaker, would Mr. Friend consent to interrogation, please?
The gentleman indicates he shall. The gentleman may continue.
Mr. Speaker, I'd like to refer back to the language in your amendment that was previously adopted, that language that the Murphy Amendment would strike. Now, I'm looking at page 5 of your amendment. There are two places where your language makes reference to a signed statement. woman has to sign one statement or the other. And the language says that the statement shall bear a notice that any false statement made therein is punishable by law. What law, under what law would that be punishable, and what would the punishment be?
Yeah, as I indicated in a detailed memo which I sent, there are two existing laws which are basically identical. One in the existing Abortion Control Act and one in the Crimes Code from 1973. And give me the slide from the front.
This is the Abortion Control Act. This down here's the one, C.
Okay. Statements under penalty, and this is both in the Crimes Code for the last 16 years, and it's in the Abortion Control Act. A person commits a misdemeanor of the 3rd degree if such person makes a written false statement which such person does not believe to be true on a statement submitted as required under this chapter, meaning the Abortion Control Act, bearing notice to the effect that false statements made therein are punishable. That's both in the Abortion Control Act of '88, and it's in the Crimes Code unrelated to the abortion issue since 1973. And what it says is if you provide an unsworn statement, which you know to be false, which has on it a warning that a false statement is punishable by law, it's a 3rd-degree misdemeanor.
And what is the punishment for that?
3rd-degree misdemeanor is punishable by no mandatory minimum sentencing, maximum from 0 to 1 year imprisonment, and from 0 to $2,500 fine.
Okay. Thank you, Mr. Speaker. Speaker, I'd like to be recognized for a moment to speak.
Is the gentleman asking for his additional 2 minutes?
Yes.
The gentleman is recognized and is in order.
Thank you, Mr. Speaker. Mr. Speaker, I would simply urge that we approve the Murphy Amendment. This is one of the sections of this legislation that is quite questionable in terms of its constitutionality. There are a lot of people who are of the opinion that this kind of language is indeed unconstitutional. The real issue, though, is what does it do to women? What we would really do if we enact this kind of language is cause many women to simply lie. I don't believe the language is enforceable at all, even given the statement that's going to appear on these statements, or the words that will appear on this statement that it's punishable by law. That really is not going to be understood by a woman. She's really going to have no real notice about what the devil that even means. If a person is really pushed, and I think we're talking about reality, if a person is really pushed, they're presented with the statement that they've got to sign, they're going to sign practically anything that's put in front of them. I think it's a mistake to add this kind of language. I don't think it's enforceable. I think others very eloquently have made the point. It's very demeaning to women, though. I would urge that, again, we adopt a reasonable amendment that's been put forward, that we approve the Murphy Amendment. Thank you, Mr. Speaker.
Chair thanks the gentleman. On the amendment, the chair recognizes the gentleman from Allegheny, Representative Gamble.
Mr. Speaker, I rise to oppose the Murphy Amendment. If indeed you are pro-choice today, you should support the Murphy Amendment because that's what it's all about. Right. However, if you are pro-life, you should oppose this amendment because pro-life recognizes that there is a marriage and that there is a father and a mother of that unborn child that is about to be killed. To ask that the father be notified that the unborn child is going to be killed is very little to ask. I ask that we vote no on the Murphy Amendment.
Chair thanks the gentleman. Chair recognizes the lady from Philadelphia, Representative Harper.
Thank you, Mr. Speaker. I rise to support the Murphy Amendment. This amendment is just as silly as the amendment that Representative Friend presented on a woman cannot get pregnant being raped. And this amendment sets a double standard for women, for single women and married women. And Representative Friend is living in the dark ages. Women are working today. We can use our own minds, our own money, and we don't have to ask our husbands about having an abortion. Single women out there certainly don't have to ask their boyfriends about having an abortion, and he does not mention the women out there. Unfortunately, a lot of women are on dope today, and they don't even know the father, which is pathetic, but it's happening. We're living in a new age, not in the dark ages, Representative Friend. Women can do with their bodies and their lives as they please. Men can no longer shut us back in the house and tell us what to do. We are on women today.
Chair thanks the lady and recognizes the gentleman from Philadelphia, Representative Litton.
Thank you, Mr. Speaker. Speaker, I was wondering if Representative Friend would stand for a brief period of interrogation, please.
Representative Friend indicates that he shall be interrogated. The gentleman may proceed.
Thank you very much. Mr. Speaker, could you explain to me what is meant by diligent effort? What constitutes a diligent effort on the part of the spouse in trying to locate her husband?
I think the words speak for themselves. I think she has to ascertain in the statement that she made a diligent effort to contact her spouse and was unable to do so. I'll tell you what it would not include. It would not include, to answer your question, the scenario under Mr. Richardson's case where the spouses haven't seen each other in 3 years. Because if they haven't, obviously the father of the unborn child isn't the husband unless I've missed something.
Does diligent constitute trying to find the spouse 1 day, 2 days, 3 days, 4 days? What constitutes diligent?
All that's required, in fact, is the woman states she made a diligent effort. Now, obviously, if they live together as husband and wife and are not living apart, there is no way they could say that's a diligent effort because, in fact, they're living together. But there can never be legislation drafted that takes in every consideration. That is why, in fact, we've left it up to the discretion of courts in situations as to what's diligent, what's reasonable. I mean, the bill's replete with language on reasonable behavior. We don't think that that's an unenforceable phrase. And we think under this situation, it is in fact a reasonable one.
Mr. Speaker, I would also like to ask, in regards to infliction of bodily injury, you made reference to a woman indicating that that failure to provide that by providing information to the spouse, notice to her spouse is likely to result in the infliction of bodily injury upon her by the spouse or another individual. I would like to know what...
Mr. Litton, do you care to use your additional 2 minutes at this time?
Yes, I would, Mr. Speaker.
The gentleman is in order and may proceed.
I would like to know under what circumstances would she have to indicate, or what proof would she have to provide to indicate that she feels that she would be threatened of bodily injury if she provided this information?
She has to state it on the unsworn statement. Now, what you're doing is arguing against exceptions that we've made and aren't even required by the Fifth Circuit, where we've bent over backwards. Now, if in fact there's a husband who disputes that, that would then be a factual situation as to whether or not there was any facts present which would lead a woman reasonably to believe that she would be placed in danger of serious physical harm by the spouse or another. And again, we bent over backwards. Maybe it's not the spouse, maybe it's the father-in-law, maybe it's a brother-in-law, maybe it's someone like that. So again, these are exceptions that we made which go far beyond what are necessary.
Mr. Speaker, if I can make a statement, please.
The gentleman, Mr. Litton, wants to care to make a summation statement?
Yes. Thank you.
The gentleman is in order and may proceed.
Mr. Speaker, it appears to me that we're going tremendously into individual family rights and decisions. I don't know how far-fetched this House is going to continue to intervene in the rights of an individual family. Once again, we are making decisions that should be made by that husband, by that wife, in consultation. But we should not impose some sort of form requiring a woman to in fact, sign a statement indicating what she has or has not done based upon her interpretation of what is diligent, what is personally perceived as a threat to a bodily injury to her. We should not impose that upon the family. This House is going far-fetched in doing that. I would like us to support the Murphy Amendment.
Chair thanks the gentleman. The chair recognizes now the lady from Philadelphia, Representative Josephs.
Thank you, Mr. Speaker. I rise again in support of the Murphy Amendment, and I'm interested to note here how difficult it is for any of us to get the attention of the members of the House. It reminds me, in contrast, about how careful we were when we worked on the ethics bill, which would affect our lives, and how we listened and how we dealt with every little point for hours. There was no 2-minute rule. Everybody here who is tossing this off as an unimportant issue, I hope you can explain to the public your disrespect for the lives and health and thoughts of the women of this state. And secondly, I was very interested to hear the gentleman from Wayne complain about men being used for stud service. Very few people here seem to mind that women are being used as brood mares. I ask for support of the Murphy Amendment. Thank you, Mr. Speaker.
The chair thanks the lady and recognizes the gentleman from Philadelphia, Representative Thomas.
Thank you, Mr. Speaker. Mr. Speaker, may I interrogate the Speaker?
Do you care to interrogate Representative Friend?
Yes.
The gentleman indicates he shall be interrogated. The gentleman may proceed.
Mr. Speaker, why did you use the language shall as opposed to will or may?
Shall was mandatory as opposed to may. It's a standard. We're doing what we did last term, if you remember. We passed paternal notice overwhelmingly. The reason why we're not doing it this time is spousal notice has already been ruled as constitutional by a Circuit Court of Appeals. This is nothing new.
Mr. Speaker, I'd now like to offer my comments.
The gentleman is in order and may proceed.
I have sat in the House and have not had any comment with respect to many of the amendments that have come before the House. I've voted in a manner that I considered to be correct, and I've restrained from offering any comments, but in the face of this amendment, I am compelled to urge every member of this House to reject the Friend Amendment out of hand and to support the Murphy Amendment. And I ask for your collective and individual support for the Murphy Amendment for two reasons. Number one, if it is in fact true that we are not attempting to impose our will on women, then we have no business using the language shall. Because if you apply the basic rules of statutory construction, when you use shall is requiring affirmative conduct. So even though we are calling this notice, it is not notice in effect. It is a
Does the gentleman require his additional 2 minutes?
Yes.
Gentleman's order may proceed.
We're doing more than requiring notice. We are reaching out for consent. And we are in effect imposing our will on women. And I think that there's a general consensus in this body that women should have a right to choose as to what they do or do not do with their body. And I think that although Mr. Friend had good intentions in drafting this particular section of his bill. But I think if we go forward with this, then we need to be prepared to go back to our districts and say to the women of our districts that we have in our own arena decided what is best for you. Ladies and gentlemen, and to my colleagues, I think that in good faith, we have no other choice but to vote for the Murphy Amendment. An affirmative vote for the Murphy Amendment is a negative vote against this body attempting to impose its will on the thousands of women in the Commonwealth of Pennsylvania. Thank you.
Chair thanks the gentleman. The chair recognizes the gentleman from Allegheny County, Representative Trello.
Mr. Speaker, I think everybody will agree that when a woman is carrying a child, it's probably the greatest moment of her life, and she has very strong feelings to that. And I might add, a woman is never more beautiful when she is carrying a child. But fathers have feelings too, and they're concerned about that blessed event also, and I think they should have the right to know if that wonderful miracle of God is going to be aborted or not, and I rise and urge everybody to oppose the Murphy Amendment for that reason. Thank you.
Chair thanks the gentleman and recognizes the gentleman from Northampton, Representative Grupo.
Thank you, Mr. Speaker. I rise to oppose the Murphy Amendment. My wife and I have been blessed with 4 children, and she frequently reminds me, particularly when it comes time to discipline them, that they are my children. And I presume they are my children before they were born, and I have a right as a father, and I believe every father has a right. We are talking about women's rights today. What about men's rights? Men, the fathers, the husbands, have a right to know if their wife plans to have an abortion of that fetus, unborn child, whatever you call it. I believe we should defeat this amendment because it is wrong and it is against life, and I oppose it. I hope you do too. Thank you.
Chair recognizes the gentleman from Lehigh, Representative Snyder.
Thank you, Mr. Speaker. May I please interrogate the maker of the original amendment?
Chair indicates that Representative Murphy will stand for interrogation.
No, I'm sorry, Mr. Friend.
Oh, the chair indicates that Representative Friend will stand for interrogation. The gentleman is in order and may proceed.
Thank you, Mr. Speaker. Mr. Speaker, the statute only requires notification. What form of notification is required?
Requires a statement to be given to the doctor signed by the woman that she in fact has notified her husband. We do not get into over-restrictive saying it's got to be a signed statement, it's got to be by telephone, it's got to be in person. That notification is up to the woman. As long as she gives notice to her husband that she's pregnant with their child.
Mr. Speaker, does the language of the Abortion Control Act, which says that it's the Commonwealth's interest to promote the integrity of the marital relationship and to protect the spouse's interests in having children within marriage, give the husband standing to oppose the abortion in a court of law?
Absolutely not. It's very important to remember, Mr. Speaker, we're talking about spousal notice and not spousal consent.
Mr. Speaker, does it give any standing for the husband to take any action against the physician who may have performed the abortion?
For the husband, well, let me put it this way. If the physician performs the abortion without receiving the statement from the woman, then it's a violation of the law. The husband can proceed civilly against the doctor who performed the abortion on his wife without receiving the required notice, and also it's a criminal violation.
Where does it give the right for the husband to take civil action against a physician?
Of our amendment that we passed, page 5, lines 34 through 47.
So you're saying that that is part of the action that the husband can take?
That's correct.
I'd like my second 2 minutes, please.
The gentleman is in order and may proceed.
Mr. Speaker, can the husband take any action at all against the wife?
No.
Mr. Speaker, what is the purpose of the notification? if there is no standing for the husband to actually protect the rights that we are supposedly giving him?
Good question. Two purposes. Number one, as the Fifth Circuit indicated, one of the things that a prospective husband and wife will discuss before marriage is whether or not they wish to have children. And if one does and one doesn't, that may be a reason not to enter into the marital context. Similarly, if in fact within marriage it's discovered that one does and one does not want to have children, that might be a reason for a spouse to make a determination as to whether or not to continue that marital relationship, since either he or she's rights to have children, if the other does not agree, don't exist. The other reason is, as indicated, I believe, by Mr. Foster, but it might have been Mr. Bermelin, is to generate a dialogue. And it's a pity it has to come down to this. Very frequently, particularly a young woman becomes pregnant, she's married, my husband doesn't want it, he's going to be furious, has the abortion. Only to find out, sadly, later, that forget finances and all that, the father said, that was my baby. Because you see, there's one thing, Mr. Speaker, we have to remember more than anything else. Abortion is forever. That's the two reasons, Mr. Speaker, as well as to state a public policy, which I don't think outrageous, that a husband at least has the right to know that he's the father of an unborn baby who's going to be killed.
Thank you, Mr. Speaker. Mr. Speaker, I just am opposed to this. I am in favor of the Murphy Amendment. I think that this is one of the most worrisome aspects of the Control Act, and I feel that the constitutionality of it can be very easily challenged based on the ambiguity of many of the questions I've stated. Thank you.
Chair thanks the gentleman, and the chair recognizes the gentleman from Philadelphia, Representative Hughes.
Mr. Speaker, should I run over my first 2 minutes? I'd like to be extended into my second 2 minutes, please, sir.
The gentleman is in order and may proceed.
Thank you. Mr. Speaker, I rise in support of the Murphy Amendment, and I rise so for one primary reason. On November 19th, 1988, at a small church in West Philadelphia, I took my wedding vows and made a commitment to my wife. Prior to that time, my wife and I established the parameters of our relationship. At that moment, those parameters were affirmed by our Creator. And after that moment, my wife and I continue to establish our parameters for our marriage. And it is my belief that every one of the other members of this House of Representatives has established for them and their spouse their own parameters for their own relationship. I warn everyone that if we do not pass the Murphy Amendment, that we will be in the process of falling down that slippery slope of interference by other individuals in our own relationships with our own spouses. That relationship with my wife is mine and mine alone. It is the parameters that we set up that determine the direction of that relationship. We communicate on those matters and those things that we determine we should communicate on. And no one else, Mr. Speaker, no one else is involved in that process. I rise, Mr. Speaker, to affirm the relationship that I have with my spouse and to support the Murphy Amendment, and I rise also to not allow anyone else in this room, in this state, or in this nation to interfere with the personal relationship that we have.
Chair thanks the gentleman and recognizes the gentleman from Allegheny County, Representative McVeary.
Thank you, Mr. Speaker. Would Representative Friend stand for a brief interrogation?
Representative Friend indicates he shall. The gentleman may proceed.
Representative Friend, is it an accurate understanding that I have that one of the goals of this legislation is to bring Pennsylvania law into compliance with the constitutional standards set in the Webster case?
I think, as I indicated before, Mr. Speaker, it's our opinion that Webster gave us a rational basis decision and permits us to go farther than we've gone, not only to restrict and regulate with respect to abortions, but to also extend additional protection to all of the victims, the baby, the mother, the husband, etc.
Did the Webster decision address the issue of spousal notice?
No, it did not, Mr. Speaker.
Did the Missouri statute that was subject to the Webster decision deal with the issue of spousal notice?
No, it did not, Mr. Speaker.
Has the United States Supreme Court ruled in any case, to your knowledge, that spousal notice provisions are constitutional?
Yeah, to the best of my knowledge, Mr. Speaker, the issue has not been considered by the United States Supreme Court. It has been considered by the Fifth Circuit and has been ruled constitutional.
Am I correct in interpreting your answer that the United States Supreme Court has not determined that spousal notice provisions in such statutes are constitutional?
Has not either way. Has not said it's constitutional, has not said it's unconstitutional.
So that the statutes that have been tested through the courts to the United States Supreme Court have not yet had that provision in it for consideration by the Supreme Court of the United States.
To the best of my knowledge, spousal notice has not yet come before the United States Supreme Court.
The issue of spousal consent, however, has come before the United States Supreme Court, has it not?
I believe in the Danforth case, that's correct. That's consent, however, not notice.
Right. And the United States Supreme Court ruled...
Does the gentleman care to use his second 2 minutes?
Ruled that spousal
Gentleman's in order.
consent was unconstitutional, did it not?
That's correct. And again, it's consent, not notice.
Now, you indicated that a Florida circuit court has ruled that spousal notice is constitutional. Did you not say that?
That's correct. I also indicated that the case was remanded to Florida because, unlike our statute, it did not have an exception for where the husband is not the father of the unborn child.
Is it not accurate that the circuit court in Florida remanded that case and the district court determined that the spousal notice section was unconstitutional?
That is quite correct. And once again, as I indicated, because unlike our legislation, it did not have the exception, and we have 4, but the Fifth Circuit only had a problem because there was not the exception where the husband was not the father of the unborn baby.
So, actually, however, irrespective of the fact that this statute or this proposed legislation has more factors than that which has been previously ruled upon, there has not been a ruling that this spousal notice section is constitutional.
There has been neither a ruling that it is or is not.
Is it then the intention of the maker of the original amendment, yours truly, or excuse me, you, is this section designed to test from a constitutional perspective the acceptability of a spousal notice section?
No, it's not, because we don't think this is a test of Roe versus Wade. In point of fact, we believe that even within Roe versus Wade, this will be ruled by the court as being constitutional. We do not think this is a provision which would permit the court to look at the fabric of Roe versus Wade.
Nevertheless, the spousal notice section does go beyond any provisions of that sort which have been found to be constitutional by the United States Supreme Court to date.
Simply hasn't been decided, and I'm unaware that we've ever refrained from running legislation of any type that the court hasn't ruled on one way or the other.
Have we ever dealt with the issue of spousal notice in any of the previous abortion control statutes that have been passed in the General Assembly?
In '87, we had paternal notice.
The gentleman's time is up.
Thank you, Mr. Speaker. I urge a favorable vote on the Murphy amendment.
Chair recognizes the gentleman from Allegheny, Representative Pistella.
Thank you, Mr. Speaker. I was wondering if the gentleman, Mr. Friend, would stand for a brief interrogation, please.
The gentleman indicates he will. The gentleman may proceed.
Thank you. Sorry, I realize it's been a long day for everyone. I have a question, though, that I've not been able to rectify. In looking at the language of your amendment, it requires spousal notification. My question is, in the state of Pennsylvania, we have most recently adopted a divorce code that provides for a unilateral divorce if one of the two parties would agree, in fact, to separate for a period of 3 years. Under the terms of that act, that statute, how would a spouse, the man, have in fact standing under the provisions contained within your amendment?
Well, number one, if they're not divorced yet but living apart, and the husband, and he's still the husband, is the father of the unborn child, there has to be notification. If in fact they're living apart and the husband is not the father of the unborn child, as you all know, that's one of the exceptions.
All right. The other question that I have is, how would this relate to common law marriages?
In point of fact, a common law marriage is recognized in Pennsylvania as a marriage.
Well, I realize that, but if there were a separation of one of two parties during the course of a common law marriage, what would be the net effect?
Well, in point of fact, if they stopped holding themselves out as husband and wife, they would no longer be married. If, in fact, there's a common law marriage and one of the requirements is they're holding themselves out as husband and wife, then in point of fact, that would apply.
Thank you, Mr. Speaker. I've concluded my interrogation. I would just like to make a brief statement.
Gentleman is ordered. May proceed.
Thank you, Mr. Speaker. What Mr. Friend has done, ladies and gentlemen, is to indicate that, according to his interpretation of his amendment, that it would require spousal notification. Yet the two cases that I have pointed out for consideration by the membership deals with the unilateral divorce provision, wherein upon separation the spouse in fact gives up all rights to property that was acquired and held during the course of that marriage. Yet we're instituting a provision that would seem to go beyond that if in fact an individual has already given up or elected to give up the responsibility to that marriage.
Does the gentleman care to use his second 2 minutes?
Yes, Mr. Speaker.
Gentleman is ordered. May proceed.
The second provision in relationship to the common law marriage, I am told, is oftentimes a bone of contention. And in fact, the two people would live together in common law status and would agree to separate or divorce. Oftentimes the question becomes, were they in fact married? And if not, when in fact would they be separated or divorced? My concern is that the intention of Mr. Friend with his amendment does not adequately address those two provisions. It's for that fact that I would strongly recommend that the wisest course of action under those circumstances would be the adoption of the Murphy Amendment. Thank you, Mr. Speaker.
The chair thanks the gentleman and recognizes the lady from Beaver, Representative Laughlin.
Is that on? Thank you, Mr. Speaker. As a woman and the wife of a former member of 36 years, I believe that my spouse would have the right to know, and I believe also that just as he has the right to know that the unborn child has a right to live, and I would say defeat the Murphy Amendment.
Chair thanks the lady and recognizes the gentleman from Berks, Representative Lay.
Thank you, Mr. Speaker. May I speak on the amendment?
The gentleman is in order and may proceed.
Thank you. The issue here is simply spousal notification. That's all. It's not some type of male superiority. It's not a lot of legal mumbo-jumbo. It simply states that the spouse should be notified. What this does, it does not destroy the woman's rights. It does not boost the man's rights. It protects the integrity and the sanctity of the family. And that's a responsibility of government, to protect the institution, the most important institution in our society, the family. And the Murphy Amendment would further erode that. And Lord knows we do enough in this hall to destroy family life in this state. I would just ask that you would oppose the Murphy Amendment, support the bill as it is. And I would ask all the males in here who have the specific parts they were born with to stand up and be counted. Thank you, Mr. Speaker.
Chair thanks the gentleman and recognizes the gentleman from Montgomery, Representative Sauerman.
Thank you, Mr. Speaker. Mr. Speaker, I'm amazed to hear those who are so pro-family and pro-life talk as though there is no integrity in a marriage. That somehow we have to protect the family rather than protect the institution of marriage, which allows that trust to function. We want to tell people how to be faithful. I've listened to a lot of constitutional arguments again, and I get confused. Evidently, the Constitution somehow says that a spouse should be notified, but that if the father is not the spouse, he doesn't have to be notified. I'd like to see where in the Constitution it makes a definition or a separation between the father as a spouse or the father as a non-spouse. And I think that there is a great deal of question as to the matter of constitutionality here, but I think besides that, we should support the Murphy Amendment, and let's let family integrity be family integrity based on faith and mutual understanding rather than what we in Harrisburg try to make it to be. We can't legislate that any more than we can morality. Thank you, Mr. Speaker.
Chair thanks the gentleman on the amendment. The chair recognizes for the second time Representative Murphy.
Thank you, Mr. Speaker. Mr. Speaker, I thought the interrogation of the maker of the original amendment was enlightening. We have heard time and again that the victims of the abortion are the mother and the baby and the father, and that in all cases the woman is the victim. Yet, in this particular section, the only place in this legislation we make the woman the criminal. Now, I want you to remember that, because this section forces the woman, against maybe her better judgment, to become a criminal, to lie on a statement because she's fearful of what might happen if she signs that statement. That no place else in this legislation is the woman made the criminal. It is in this section. I want you to have to go back to the women in your district and tell them, if they acted out of good conscience, made a decision not to inform their husband out of good conscience, that they're going to be criminals for that act. That's what you're doing today. I don't believe that's fair. I don't believe that's good government. And I don't believe that solves the problem. And that's the second point that Mr. Friend made today. Mr. Friend said that this particular section does not really go to Roe versus Wade. It does not deal with the issue of abortion directly. It does not deal with the woman's right of choice or the life of the baby. It deals with a peripheral issue. It deals with what we've heard about all day long, the relationship in a marriage and the ability of a husband and a wife to communicate. That's not something we should be involved in. And further, it's not something we should criminalize if a woman makes a choice not to notify her husband and not to sign a document. Keep that in mind. You're turning a woman not into a victim with all the rhetoric I've heard. You're turning her into a criminal on this one particular section. I ask your support for the amendment. Thank you.
Chair thanks the gentleman. On the question of the amendment, the chair recognizes the Representative Friend.
I once again oppose the Murphy Amendment, and let's do just that. Let's any of us go back to your average constituent and say, do you think a husband has a right to at least be notified? They'll be shocked that under the law right now, they don't have that right. We're not talking about consent. We're merely talking about notification. And how the family unit in the marital context somehow become the enemy is beyond me. Nowhere in this bill is a woman made a criminal for having an abortion. All we're saying is, if in fact you violate an existing law, knowingly a false statement, then it's a misdemeanor 3. I don't think anybody has a problem by enforcing an existing law that says you can't lie in the statement. We made it unsworn so we don't violate the woman's right to privacy with respect to a notary public. So do just that on this issue. Go back and ask your constituents, and you're going to find out that they are appalled that a husband doesn't even have the right to know. This is sound legislation, and I sincerely hope that we overwhelmingly defeat the Murphy Amendment. Thank you, Mr. Speaker.
On the question of agreeing to the amendments, the yeas and nays will now be taken. Members will proceed to vote. Have all the members voted? Have all the members voted? The clerk will record the vote. On the question of agreeing to the amendments, the yeas are 75, the nays 125. The amendment fails.
Mr. Speaker. Mr. Speaker.
The chair recognizes the gentleman, Mr. Dorr from York. What is the purpose the gentleman rises?
Mr. Speaker, would I be in order to notify the members that I'm about to introduce the personal care home bill, and that anybody who wants to co-sponsor it should come to the table in the rear to do so before I put it in the hopper?
The gentleman so stated. I guess he is in order at that point. Chair recognizes the gentleman from Allegheny, Representative Trello.
Mr. Speaker, on that last vote, my switch malfunctioned. And if I could have voted, I'd like to be recorded in the negative on the Murphy Amendment.
The record will so designate. The question recurs, shall the House agree to the bill? The chair recognizes the lady from Lehigh, Representative Ritter, who offers the following amendment, which the clerk will read.
It's Amendment A 3477. Amend Section 4, Section 3211, page 7, lines 36 through 39.
Will the House agree to the amendment? The chair recognizes the lady, Representative Ritter.
Thank you, Mr. Speaker. This amendment is a redraft of the Hagerty Amendment dealing with abortions performed after 24 weeks and defining health exceptions to that ban. So we retain the same language as before, which is the death, substantial risk of death, serious physical injury, serious physical illness, or protracted loss, and we've added the word serious impairment and we've added the word major bodily function. So we have narrowed it substantially in terms of impairment of bodily function, and we would ask for your support on this amendment. Thank you, Mr. Speaker.
Chair thanks the lady. He recognizes the gentleman, Representative Friend from Delaware.
Thank you, Mr. Speaker. It's virtually identical to an amendment, I believe the Hagerty Amendment, which we defeated. Once again, the issue here is health. And once again, we very carefully weighed life of the mother, life of the baby. Scales come down for the mother. Serious, substantial, and irreversible impairment of major bodily function of the mother against the life of the baby, once again in favor of the mother. But when you get into the general terms, serious physical injury, serious physical illness, or protracted loss or serious impairment of a major bodily function, what's protracted, what's serious? Once again, we're back into the open-ended health exception, which we've already rejected on, I think, 3 previous occasions today. I ask for a negative vote, Mr. Speaker. Thank you.
Chair recognizes the gentleman from Chester, Representative Barun.
Mr. Speaker, point of order. Isn't it
Gentleman shall state his point.
Isn't it against the rules of the House to consider the same amendment over and over again?
It's quite different.
Chair rules that the amendment is similar but not identical, and the amendment is in order.
Is the rule identical? Identical as to words or identical as to content?
I don't know how you got it.
As long as there's a comma change, it's good for me.
Under Rule 27, it has to be identical, and the amendment is in order. It is different. Do you care to speak on the amendment? The chair recognizes the gentleman from Lehigh, Representative McHale.
Thank you, Mr. Speaker. Mr. Speaker, in a sense, I admire the certainty with which the gentleman, Mr. Friend, and the lady, Miss Ritter, can approach this issue. I do not approach this issue with that same absolute certainty and the correctness of my position. I frankly approach this question with some doubt. There are those of us in the chamber who believe both in the right to life and in the right of privacy, and in the context of this specific amendment, a careful balancing between the two is called into order. Now, throughout the course of the afternoon, Mr. Speaker, I have supported some pro-choice amendments and strongly opposed some others. For instance, earlier in the afternoon, I opposed the Hagerty Amendment, the one to which Mr. Varun made reference, because I believe that in the 3rd trimester of a pregnancy, only the most exceptional of circumstances can justify the taking of that fetal life. Mr. Friend has included some of those exceptional circumstances in the original text of his amendment. I opposed the Hagerty Amendment because I thought the door was open too wide. In the Hagerty Amendment, may I call for order, Mr. Speaker?
The gentleman is entitled to be heard. The House, please be in order.
Thank you, Mr. Speaker.
Gentleman may proceed.
Earlier this afternoon, I opposed the Hagerty Amendment because it would have allowed a 3rd trimester abortion simply if the standard of an impairment of bodily function were met. I don't think that an impairment, a minor impairment, of a relatively minor bodily function justifies ethically or legally the taking of that fetal life at that stage in the gestational period. What I would point out to the Ritter Amendment is quite different. The Ritter Amendment, now before the House, calls for a serious impairment of a major bodily function. The gentleman, Mr. Friend, opened the door when he provided a health exception in the 3rd trimester. I believe that the lady, Mrs. Haggerty, went too far in terms of the text of her amendment. The Ritter Amendment would allow the taking of that life only under the exceptional circumstances of death, substantial risk of death, serious physical injury, serious physical illness, or protracted loss or serious impairment of a major bodily function. I believe, if I may have my second 2 minutes, Mr. Speaker.
The gentleman is in order and may proceed.
And I'll take just 3 moments to conclude. I believe that this strikes an appropriate balance. There are many of us who respect profoundly the right to life in the 3rd trimester. And only the most exceptional of circumstances, such as those carefully now drawn in the Ritter Amendment, can justify the taking of that life. These are difficult decisions. In contrast to the earlier amendment, I believe this one is carefully drawn, and I urge support for the Ritter Amendment.
Chair thanks the gentleman and recognizes the lady from Philadelphia, Representative Josephs.
Thank you, Mr. Speaker. I'm sitting here and listening to this discussion and this debate, and as I'm doing this, I am thinking about myself going back into my district and being questioned by a woman or by the children of that woman or the husband of that woman or the brother or uncle or friend of that woman about this debate. I am wondering how I can say to those people, it didn't really matter to me that you have a really serious kidney problem, that you have a condition which was aggravated by your pregnancy, that you are going to be in pain because of my vote against the Ritter Amendment. I hope that everybody who is listening to this debate, which is not too many people in this House, has formulated the answer to that woman when that woman asks him or her that question. It's important. I want to make sure that the record shows this is important. Women's lives and health, women's safety, women's thoughts, women's philosophies, women's private philosophical beliefs hang in this balance. And I'd like to know how you can justify a no vote to your constituent. Thank you, Mr. Speaker.
Chair thanks the lady and recognizes the gentleman from Allegheny, Representative Volaz. Chair doesn't see the gentleman and recognizes the gentleman from Chester, Representative Pitts.
Thank you, Mr. Speaker. We have considered this amendment, similar amendments, now this is the 4th time, I think. Again, this is the broad health of the mother exception. The words here, protracted loss or serious impairment. What does protracted loss mean? Does that mean for a few weeks, that for a few weeks of illness you can trade off the life of the child for this health of the mother exception? Mr. Speaker, I think we're almost getting to filibuster here the way these things are being offered. I would suggest we defeat this. We've already voted several times.
Chair thanks the gentleman. On the question of the amendment, the chair recognizes for the 2nd time Representative Ritter from Lehigh.
Very briefly, Mr. Speaker, I just want to point out that we are not talking about very broad amendments here. This is a very narrow amendment. It's drawn specifically to address serious health problems that affect women at this point in the pregnancy. And we are not talking about an abortion in terms of saline or D&E. Again, we're talking about an early delivery, and we're talking about allowing the physicians to be making those decisions, balancing the interests of both patients that they have at the point of viability, but certainly allowing a woman to make a decision about abortion in these very narrow cases of substantial risk of death serious physical injury, serious physical illness, protracted loss, or serious impairment of major bodily function. I think, Mr. Speaker, that this amendment is very narrowly drawn and will address the serious concerns that members have in this area, and I would ask for an affirmative vote.
Chair thanks the lady. On the question of agreeing to the amendments, the yeas and nays will now be taken. The members will proceed to vote. Have all the members voted? Have all the members voted? Will the record note that Representative Trello wishes to be voted in the negative? Have all the members voted? The clerk will record the vote. On the question of agreeing to the amendment, the yeas are 89, the nays 113. The amendment fails. Chair wants to recognize now the chairman of the Appropriations Committee from Philadelphia, Representative Piesky.
Thank you, Mr. Speaker. Mr. Speaker, there will be a brief meeting of the Appropriations Committee at the rear of the chamber immediately.
Will the members of the Appropriations Committee retire to the rear of the chamber for a meeting? The chair recognizes now the Majority Leader from Philadelphia, Representative O'Donnell.
Thank you, Mr. Speaker. I would like to address the subject of our schedule. So I'd like your attention for just a minute. We're going to take a break now. The cafeteria is available. I'm going to suggest a recess, returning here at 7:30. Now, let me finish. 7:30 gives you enough time to eat. It does not give you enough time, obviously, to go out and eat. So we're going to start promptly at 7:30. So it's 7:30, and this place is obviously under scrutiny. We will begin debating and we will begin voting. I would urge you to consider two other ideas. One, do we really need to be here tomorrow? That depends on the authors of the amendments, and it depends on your belief about the importance of what you have to say on any given amendment. I urge you to be succinct. Now I urge you to be more than succinct. We're coming back at 7:30, and we're going to try and finish tonight. Thank you.
This House stands in recess till 7:30.
And that concludes this portion of our coverage of debate this week in the Pennsylvania House of Representatives on abortion legislation. The remaining 3.5 hours of debate will air here on C-SPAN 2 at approximately 2:30 p.m. Eastern Time on Sunday. Coming up next, it's the annual Democratic National Committee Gala.